Board of Adjustment in Madison, New Hampshire. So, let's see. Mark, can I ask you to lead the pledge of allegiance?
Thank you. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so the, let me just ask a question. We do have 5 people here tonight. It's great. So, well, actually, we have 6, right? So, are you okay being elevated, Mark?
Oh, I can be elevated, sure.
Yes, and that'll let,
If-
we have Rich Ventura with us tonight. This is his first meeting officially on the board. So we'll give him a chance to watch, and he'll be involved in discussion, but the 5 voting members then will be Jennifer, you're a regular
Am
now
I,
too.
I'm now a regular,
No,
I'm
is she
sorry.
not a regular?
She's
She's still an
No, I'm
alternate?
still
Yeah.
an alternate until
Yeah.
someone says
Oh, okay, well
no.
then we're raising Mark and Jennifer to voting members tonight.
Gotcha.
Okay.
And we have Rich as an alternate. Okay,
If it's the
I-
will of the board.
It is. I have a good point. Is
The
there
board
a
will.
process?
so actually, process-wise, that decision is the chairman's, but I wouldn't do it if the board objected.
And when have we ever objected? Is there a process to sort of, I don't wanna say permanently, but at least until the end of her term, now that we, have 1, 2, 3,
Yeah,
4?
Technically, it's the Board of Selectmen's choice to change this permanent status of the
Oh.
member. Okay.
Yeah, I don't, on the ABC, I can appoint members.
That's
So-
because the ABC is elected where this is appointed.
Yeah, and the appointment, the right, the responsibility to appoint. Now,
Weren't we
we could ch-
elected?
no,
Really?
We weren't elected.
You were appointed.
yeah, you kinda lost track of it.
I have,
That's okay. We should get ahead of onto our business tonight.
Okay.
Okay, so we have case, let's see, 2505, which is effectively a repeat of an earlier case which expired. And this case is continued from last month. So Kate, would you read whatever needs to be done in terms of public notice, et cetera, et cetera?
2505, variance request for Mark Conti, Samuel Schreiber, for property located 14 Underwood Road, tax at 109 121. Article 5, section 5.9E of the zoning ordinance permits the house to be 49.90 feet from the center line of the roadway where 65 feet is required. Also a variance request from Article 5, section 5.9C of the zoning ordinance to permit the deck attached to the house to be 64.60 feet from the high water mark, 2 porch column, 75 feet is required. Mark resubmitted the application because it was incorrect, so I sent out the certified on August 5th, posted on the website on August 6th, and the Common Daily Sun on August 7th, and I don't have any other come back.
Okay, so, since we have a slightly different board tonight, I'll just go ahead and poll for conflict of interest again.
no,
No?
No.
No,
No?
No.
No, okay. So then none of the board members have any conflict of interest. I've forgotten, is there,
regional impact.
yeah, regional, well, no, I was gonna do the waiver
Certified
request.
deed.
Yeah.
I think we used this, we
We-
accepted this, well, the previous one,
Well, did we do that last time? We accepted this last time, right?
I
So
believe so,
we didn't have any. Is that,
it would be in the minutes.
Mr. McConkey, did we accept that, or did we accept the waiver? Was that?
I believe you granted a waiver to accept the plot that's in front of you.
Yeah, okay, let's,
It's up to Paul.
and does any of the board think there's a regional impact to this case?
Oh,
no.
No. Okay, so now that we clarified some of the questions that were, well, actually wanted to make sure, everybody in the room was sworn in the last time. This is a continued case, right? So I don't think we need to swear anybody in. Normally, we do swear people in who make public testimony. So, Mr. McConkey, go ahead and explain your
Thank you.
case.
Thank you, Mr. Chairman, thank you, board members. Sorry for the confusion of last month. We cleaned up the application to reflect distances that were approved in the first zoning ordinance, first zoning variance was granted. Also took the old structure off of here so that you're only looking at the new structure. And I apologize for the confusion. The folks behind us were correct that the numbers were wrong last time. So in the center of this plan shows a green outline. That is the zoning envelope for this property. The house is beyond that setback from the water, but the deck is 64.6 feet from the shore. The house sits back, it's a compromise. In the previous hearings, we had turned the building to be more to the liking of the people that were here the first time around. So we're at 49.9 feet, which I believe Idlewise is a 65-foot setback. And we have the house placed where it was placed when we were granted the original variances 2 years back, which have expired. The owner, for some reason, didn't follow through. The owner's in a position now to follow through, and they're asking to be approved for the same that they were previously applied for, and were granted. Happy to answer any questions.
Right. And Mr. Ventry, you're free to ask questions. Does anybody have a question for Mr. McConkey?
That's the new plan was put on.
I think we're fine.
I think the drawing is clear.
Yeah, okay.
So 75 feet, okay, all right. Thank you.
Thank you. Thanks for bringing it up last time, but honestly.
Yeah,
Yeah.
so I was confused.
So it's the site plan
I
and the
thought
drawing
that
is
we're
in
going
line.
back 2 steps, and
Yeah.
we had already corrected it, and it was
Yeah, no, that's
baffling to
fine.
me.
Would you like to say something?
No,
No, okay. Only reason I'm asking is because we do want to respect the fact that there are people watching on television, and if we're talking
Yeah,
in the
I do
audience,
wanna-
it's hard. Yeah,
I do
okay.
want to say something, but I do want to comment.
Okay, come up to the mic, identify yourself and comment.
So, Mr. McConkey, is all, you're through presenting?
Yes.
Oh, okay.
And identify yourself for the public. You can sit down if you want, or you can stand up either way.
Yeah, I may eventually sit, down, but.
You got it.
No, whatever,
You're too tall for it.
yeah, whatever. Again, my name is Paul Ragazio. I'm here with my wife Alma. We are the trustees of the Eagle Rest Trust, and the trust is the registered owner of the lots, the abutting lots on Little Way. We're abutting to 14 Little on the western side. Our abutting property is almost 1 full acre, and it was originally 3 separate Idlewise lots that we were able to successfully purchase many years ago, built a single house, and we had the lots combined, so it's only 1 house, 1 lot, 1 building. And we acknowledge that the proposed building by the owner is in a difficult situation because the lots are extremely small, that we recognize. Of significance here is that on the east side, opposite us, the abutting lot is also owned by the Sheros. And the 2 lots need to have a common driveway, as the road entrance to the second lot is all on the lot we're up in discussion with. So that when anything that's done with the lot they're doing, it has to be a common driveway. Before I start my comments, I do
want to express, have all the board members visited the location, or which ones have?
Yeah.
No.
Sharon?
I have.
So, okay, so you know. Please note, thank you for all visiting the location. Please note that in 2005, I'm going back a little bit, which is important, we requested a 10-foot extension of the deck at Little Loop, which was not approved by the zoning board. We appealed it, and we lost at the court, so we were not able to build an extension to our deck by 10 feet. We were advised a patio is an accepted alternate, and that, in my request, you will note I bring that up. We acknowledge the right of the owner to build a building on Little 14 Little Loop, that's a given. We are not opposed to the building next to us on Little Loop, providing it meets the zoning laws and any reasonable variance and is consistent with prior ZBA opinions. We do not object to allowing the house to be 15 feet inside the 65-foot required setback. I mean, the lot is only, as our lot is, mainly basically 125 feet deep. So if you're 75 feet away from the water and 50 or 60 feet away from the road, there's nothing.
Yeah.
You know, our building actually right now is grandfathered, because there's a little bit of outside. So we do not object to the building being inside the road setback. Actually, our building, I think, is a little bit further back. Our main objection regarding is a major concern is not the siting of the building, because it meets the 75-foot setback from the water and the 25-foot setback from our lot line. I don't know about the other lot line. In summary, we would expect the ZBA to allow the road setback variance, but deny the deck variance. That would be consistent with prior ZBA decision given to us in 2005. Also, we would hope, or we would expect the ZBA in their decision to prohibit any further driveway on the lot that would be next to us, and we would try not to have that driveway there, if that's possible. The second roadway entrance is on this,
He's on this
and as I
side.
said
For
earlier,
clarification, I'm not sure I understand what you were trying to say there.
I'm just saying I would appreciate if whatever the decisions are, that the owner of the lot is precluded from building another driveway or starting another driveway on our side of the lot. Because there's a big driveway, and it's a joint, it's gotta be a shared driveway with the other lot. So again, we would like that to be. And I just thank you the opportunity to speak, and if you have any questions, I'd be happy to answer.
Okay, I mean, I hear what you're saying. The driveway isn't part of the request tonight.
And the
And if-
driveway, actually, the entrance to the driveway on the other lot is totally on this lot.
Yeah,
No,
but-
that's true, but he has a driveway permit, which is not part of our,
Yeah, I understand, but
Right.
I'm saying the driveway that is in the plan is actually totally on the other abutting lot.
Correct.
yes, but nobody's requesting a driveway that abuts your lot.
Well, that's my
And I
comment.
don't know if we're in a position to preclude future application conditions,
well,
should they ever arise. I don't know, I'm asking,
I don't.
because it would be over a septic system
Yeah, I
anyway.
was just
I was
gonna
gonna
say,
say,
the
septic
same.
You know, I mean, no one's
there.
gonna put a drive on
Yeah,
top of a
no.
septic unless they're completely.
I'm not sure that lot line is this red dotted line
Yes.
here, is that right, Mr. McConkey?
Yes,
Right.
It shows the septic system
Right.
10.14 feet
10.14
off
feet.
the edge.
away
Right,
from it, yeah.
So I Yeah,
have room
okay,
to
I
put it.
acknowledge your request
Yeah.
that there would not be a driveway there. I see no way a driveway could be put there with
Ever.
the septic system,
in place, yeah.
yeah.
But if the septic system was moved, I mean, then they could.
But it isn't right now.
They'd have to
Yeah,
come to
I
us
know.
to move it, so.
Yeah.
Right.
We're not there.
Potentially.
So, yeah.
Well, I mean, in principle, the board can put conditions on a variance that's granted. I'm not sure there's any, anyway, we acknowledge your request for us to consider that.
Yes.
Mr. McConkey, do you wanna reply to
Sure,
any of those things?
I'd be happy to.
Mhm.
Michelle would be happy to, if the board were to move forward with approval, to make it conditional on the conditions shown on the plan, and the plan shows the driveway over to the other side. So
Right,
I don't see that being a deal breaker. The conversation from 2 hearings ago, or maybe 3 hearings ago, was the gentleman's annoyance that he was not able to add on to his house and could only put a patio. The compromise here was that there would only be a deck that can't be higher than the first level floor. And so he wouldn't be inconvenienced by having a deck that sits above that would view over to his property. And as far as the board from 2005 or 2010 does not bind the decision of this board, and they are a quasi-judicial board, they're a judicial board, and they make their own decisions. So I believe we had the compromise of if someone buys a home, they can walk out onto their deck and not have to step down to the ground. And I believe we covered that previously, and the people that are tending to buy up here, at least my customer base, are older people, and having the convenience of walking straight out is what they're looking for. The condition says it will not be enclosed or covered, which would make it impermeable. So we would like to proceed with what we have before you. We would ask the board to accept what we have here, which shows where a driveway is going to be, a septic system over to the side, and it's a small lot, and the whole reason for a variance is to the ability to come to the town to speak before your people, your town people that govern this on this day, and I think it's reasonable.
Okay.
thank you.
And
Right, I have,
as I said, my major objection is on the deck, and again, a patio is more reasonable, more maintenance-free, and, you know, actually could go beyond the 10 feet, so.
Okay, well, we acknowledge both your requests on the driveway, and we acknowledge your request that we not grant for the deck. We have criteria to assess these things, and we'll, did
that's
somebody?
all right, I have one question, yeah.
Yes, go ahead.
Just for clarification, the house is on grade and the deck comes, am I correct, so?
If the first floor,
Yeah.
typically your foundation sits a foot
Yeah.
to a foot and a half higher than
Yeah.
the grade. So when the door opens, it's that grade that it comes.
So the deck isn't up on, it's not supported on posts, it's just
Well,
slightly
it-
higher
it-
than
it
the
could-
ground?
No, it wouldn't.
No, it could be. It's
Okay,
going-
that's my point.
Well,
So we have a
it's-
grade with a house
Yeah,
on
well,
it, yeah.
it's coming 10 feet out from the building.
12 shown here, but yeah.
Is pretty much the same grade. There's about a 2-foot difference, but that happens way out at the bank.
Right,
so-
so my point
So
is,
if the door sits up a foot and a half off the ground,
yeah,
that's where the deck is going.
so the section of the house, if I'm just to do this, the house is built like this, and the deck is coming here like this, and you're
Yes.
supporting it there,
Yeah.
whichever way your picture your roof is going.
Yeah.
Yeah, So
But
the-
your
so-
slope here
Yeah.
is much slighter than
Right,
that.
so
Yes.
this height
Yep.
here is approximately 2 feet, you were saying?
That's what I
So
believe.
this thing
it is.
isn't a deck up in
No,
the,
no.
it isn't a deck flying
No,
off the
it
house.
says that right here,
And
no.
they-
Yeah, no, I'm
yeah,
reading
and
that,
they-
I
and
just
they
want to
can't-
visually
They
clarify.
can't
yeah.
put a deck above it. So-
Right,
So I
so
walk out
nothing
of my
can come
bedroom
above.
up there, and so that was
Yeah.
a compromise.
So this
they
deck,
wanted to do
this
that.
deck does not meet eye level unless you're way down low.
Right.
I mean, like in the water and out in the pond.
Well,
No.
the water's way down, so.
According to this,
Mm-hmm.
I'm sorry, I don't-
Yeah, please, Doug.
according to this,
What is this?
the map that
plan?
I'm looking at
Okay.
here, there are elevation lines.
Yes, there are.
And the front of the lake side of the house is at 75 feet, but the deck almost goes to the 62-foot elevation line, which is 13 feet. Sounds to me like the lake side of the deck will be 13 feet high when you go out to the edge
No,
of it.
no, no,
No,
no,
no.
no, that's,
That we've got,
this line here is distance from the lake.
Oh,
Right.
This
So
line
we-
here is.
I got,
That's
all right.
62 and 50
Thank
and
you.
75 are
Thank
distance
you.
from the lake.
we have 96 and
Yeah, all right,
98,
all
there's
right.
2 feet.
Yeah.
Those two
All right,
contours
all
are 2
right,
feet.
all
Yeah,
right.
I'm with you, Doug, I see where you're coming from too.
Yeah, okay.
No, there's
Yeah.
a 2-foot drop, so that's
Yeah,
all
that's
there
fine.
is
Yeah, yeah.
off the edge of the
Yeah.
deck. So this deck doesn't interfere with any eye lines, is the point I'm making.
No.
It's basically, for want of a better expression, it's a floating patio,
Yeah,
except it's not made of concrete.
it's made of wood, yes.
It's a
whatever.
deck, yeah, so
It's-
one
it's-
end
it's
is, one end is
whatever.
about a foot
Right,
and a
so
half
the
off the
front-
ground, and at the
And
other
the other is
end.
flush with the house floor,
Yeah.
give or take an
Potentially.
inch.
Yeah,
Yeah.
well, it'll be a little more than a foot and a half because
Yeah.
it drops.
Yeah, well,
a
there's,
little bit.
it's 98 to 96, or which, if I'm reading the numbers the right way around, so it's 2 feet.
Yeah.
The two contours are right there.
That's
Yeah.
Right,
So
yeah,
it's 2
so,
feet, bar the shouting.
right, so just say at the high end, it's a foot off the ground,
And at the
and at the
low
low end, it's
it's
3
2.
feet off the ground.
At max, it can't be any
Maximum.
more if these contours are correct.
Right, but the
yeah.
point is, it's level with the first floor.
Right, so
Right.
it's not something attached to the house at high level.
No,
So
It won't
even,
obstruct anybody's view.
unless you're significantly lower, it doesn't have any visual impact.
That's right, that's right.
Well, it's not
From the
gonna have.
side, even from the side, even if you were to the left or right of this house, even though it's not, you're not seeing anything high,
Unless you're
Right.
laying on the ground.
unless you're laying on the ground.
Right.
Yes, when you're out on the pond, but there's a whole house there,
Yeah,
you know,
Yeah, right, no,
so.
the deck is
Yeah.
not, the deck
The
is not.
deck is
gonna
not
be-
one of those
is
on
not-
posts.
No, we're
or-
good.
Right,
No.
that's, I'm just trying to complete, that's what I read, I mean, I,
yeah, no,
I
you're
just
right,
wanna
you're right. I was
clarify
wrong.
it with everyone.
Yeah, and the difference in grade, even all the way down to the water, is only 10 feet.
Exactly,
Yeah.
you're down to 90 here, and it's 98 there,
Right.
so eight,
Yeah.
eight-ish, yeah,
Okay,
thank you, sorry
So the
to,
deck on the
beat
far
that.
end would be a couple of feet above the ground,
yeah, max,
Correct. 2 to 3 feet
tops,
estimated.
It,
2 to 3 feet, yeah.
tops.
yeah, as the stem wall, the frost wall comes up, you know, it's
Yeah.
parallel, it's the same level as the floor.
Yeah.
So there'll be a post at the far end, but
But it isn't even as high as this table.
no.
I mean, that would,
About
that'd be
near.
dangerous to get off of that.
Well, if you have, no, you have railings
Well,
by
there'll be
code.
railings, yeah.
yeah,
You have to have 42-inch
You're not
railings.
gonna step down 2 feet.
no,
No, you
No.
have 42-inch railings and steps, I'm assuming.
yes.
Mr. McConkey,
Yes.
are there stairs from this deck to the ground, or is it a fully enclosed, cordoned off deck?
I wish I knew the answer for you on that. Some towns count stairs, some towns don't count stairs, access off of there. If there were to be stairs to go off the deck to go down to the yard, they'd have to be back against,
The house.
they'd have to
The house.
be further than 65 feet back.
Yeah, they'd be off
They'd
the
be cut
end of the
into
deck
the
one
deck.
way or the
You
other.
put them next to the house, and there's only 1 foot, so it's one step.
Yeah,
They couldn't come off here, they would have to come off here or
Yeah.
here.
Unless you did a stepped deck, which is not what you're asking
No.
for, so we're not
No, no,
even
no.
going there. So,
No.
Right, so for clarification, if the stairs are not shown on here,
they don't
There are
exist.
no
they
stairs.
don't exist, therefore they're not part of any variance that we may or may not grant.
that,
Right.
no, that's correct, in other words, if they're
I'm
not
fine with that.
mentioned, they
Because
wouldn't.
we're not on
They can
code
come-
here,
they can
this
come
is
back.
building.
One person at a time,
Yeah.
please.
You can insert them into the deck, there's a lot of things you can do.
No one is addressing the fact that it's 75 feet. It's all 65.
Yeah, I know, that's,
Well, we will address that question, that is one of the questions we'll have to address.
and again, there would be nothing built above the deck, so the deck would be,
That is the application, that it's simply a deck without a cover, without an
post.
enclosure,
No roof.
no roof.
Okay.
Of course, railing may be necessary
Yeah,
for
has to
safety.
be. No, I understand.
Absolutely.
Right.
Has to-
There are no stairs shown, so the one thing that can't be the case is they can't put stairs in such a manner that would encroach any closer to the lake than the variance they're given. Right, and there are two directions those stairs could go that don't do that.
Right.
Okay.
Okay, so let's,
Excuse me?
yes, go ahead.
I just, if we had to live with the 75-foot setback and make a patio, okay? I feel that we need to have a variance too on our house that maybe we could add to our deck. Because you're letting them have a 65-foot and we had to live with the 75-foot and no extension and a patio.
Put the application in.
Yeah,
Pardon?
Put the application in, we'll see what happens.
okay, yeah.
Okay,
Yeah.
that's fine.
Not to put too fine a point on it, but, in the protocols, we consider each and every variance request independent of any other variance request. And one of the criteria is not what happened to the
Next
neighbor. You know, that's not one of the criteria that we consider. We consider the criteria of the case in light of the 5 criteria that we'll discuss later tonight. And if they meet the 5 criteria, then we're able to grant the variance. And one of those criteria is not whether or not somebody else got a variance. So,
But the board, I mean, and the board to be fair, for lack of another word, you have to be consistent.
well, fairness is defined by the 5 criteria, and specifically in New Hampshire law, it's acknowledged that different boards may conclude different reasons for similar cases if the 5 criteria are met, and that, we haven't had that discussion yet, but I'm just saying that we will not consider whether or not you got a variance in our criteria. That's all I'm saying.
Yeah, okay.
Yeah. Okay, so let's, any other questions, and we will start to put together the findings of fact. So, first finding of
Can
fact,
we close the hearing?
no, not yet.
Not yet?
I wanna leave the hearing open while we're finding the
Okay.
facts, but, and that way we have a chance to ask questions.
Okay.
Yeah. So first point is that the house structure meets the 75-foot setback
From the
from the
water,
from the lake.
yes.
Right. Second point is that in order to do that, the house must have the, what is that, 49.9-foot setback from the street.
And the building envelope is not big enough to support a house.
Right.
Yeah.
Well, it's not big enough to support a reasonable sized house. It would support a house, but it would look like a double wide
Tiny
trailer.
home, yeah.
It would be 14 feet wide and
Yeah.
40 feet long kind
It'd
of
be a
deal.
tiny home.
Right, so the
Right.
house, the 49 setback from the street, the building envelope, because the building envelope is inadequate for any reasonable home.
Good.
Okay.
I believe in one of the prior findings
ahead.
of facts for this,
Yeah.
we also indicated that we as a board believe that the setback from the water had a priority over the setback from the road. Because this was a more sensitive area.
Okay. I'd like to put as a finding of fact that the board favors honoring the setback from the lake.
And I concur with that.
Over
Yeah.
the setback.
It's a necessity.
Yeah, over the setback from the road. Fifth, these conditions are common in the neighborhood. Are common in the neighborhood. so that a setback of less than 65 feet from the center of the road is not out of character for the neighborhood. Okay, so now we come to the deck. And the deck extends 12 feet into the 75-foot setback.
Would we, Drew, discuss in any way whether that 12-foot could be 10-foot? I mean, you know, is there a possibility of giving that some
That's a possibility.
consideration? I'm picking a number, you know,
Well,
9.
no, I know you're picking a number, but there's a process here, and the process is that we as a zoning board of adjustment are not asked to redesign the
Okay.
project. We assess the project as it's presented.
Right,
If that were to be a ground for a serious offense, then we can set a condition,
okay,
or we can deny the variance.
okay.
But what we don't do is redesign the project.
No, thank you for
I mean,
clarification.
If
In the
the,
discussion, as happened the last time,
Yeah.
you know, the agent decided that, well, maybe, yeah, it's a good idea to move, tilt the
to
house,
tilt
and
the house.
Yeah,
that's okay,
yeah,
if it comes from that side,
yeah,
But-
understood.
right?
Yeah.
Okay, so, so the
Back to
deck
the
extends 75 feet, into, no, I'm sorry, it extends 12 feet.
12 feet into the
Into-
75
into the
foot
set-
setback,
right.
yep.
Right.
Where do you get the 12 feet?
Off
size of the
no,
deck.
it's on,
Size of
it's
the
right
deck.
on the,
Dimensions
on
of the deck
plan,
are 12.
The dimension of the plan.
Comes 12 feet off the house is at 75 feet.
Oh, okay.
Yeah. Are there, well, I suppose just for the record, Kate, what was the previous case number?
Case,
With the one that expired, do you know?
same case number, I kept the same file, just.
No, the
Oh,
one
I
from
wanna know what-
2005
Oh,
or
I'm
whatever it
sorry,
was.
I'm like, what? That one's 2303.
Okay, 20, okay. So I'm gonna say this is the same request as case 2303, which variance was granted but expired. Are there other comments, findings of fact you wanna throw in?
I do, I wanna make
Yeah.
a correction though, that the deck does not extend 12 feet into the 75-foot envelope. It only extends 11.4 feet because of the way the house is situated, the 12 feet goes,
Oh,
so it's 64.6 feet,
okay, alrighty,
so,
Fair enough.
11.4
11.
feet.
yeah.
To our point of clarity earlier.
Well, I just don't want anybody to think then that,
Yep.
oh, I have 12 feet, then I can build a deck. I don't know anybody who would wanna build a
No, but
catty
you've got
wampus
8
deck.
inches difference, yeah.
Yeah.
Oh, a little more, 7.
Okay. Yeah, because the house, yeah, where the deck attaches
Yeah.
is just slightly inside the
Slightly.
75-foot, yeah, that's right. Okay, any other comments on the findings of fact?
Do we make any comments about the verticality or not, the no vertical
We
aspect?
can take the same condition as we had the last time, that,
It's actually 10.4, I'm sorry, my
Oh,
math.
11.
I'm sorry, just, yeah, let me,
Yeah.
okay,
75 minus 64.6 is 10.4.
yeah,
I don't want us to be wrong.
10.4. Mm-hmm. Okay. Okay, can we move beyond that point?
Please!
Okay, are there any other issues and findings of fact that we wanna include in here? And to answer your question, Jennifer, is that we can make a condition and we can bring the same condition that it not be covered.
Yeah.
Yeah,
And-
there's nothing above the, whatever the standard rail height needs to be permanent. What
Right.
about steps? Do we bring anything in that steps cannot go beyond this dimension, they have to be within this dimension?
No, I don't think you would need to, because the variance is for the deck. The variance says you can't go any further than 64.6 feet
Right.
into the building or into the.
Beyond those lines.
Beyond
as
those
shown.
lines, right, so you
Yeah.
would not be able to build steps that extend
Onto
down
that.
into it.
They have to
You'd
be
have
within it.
You'd have to pull your deck
That's
back.
all I want to
Yeah.
clarify.
Yeah,
Yeah.
no, that's.
Nothing can go beyond these lines.
Nothing can go beyond
Yeah.
the 64.6.
Any other questions or comments? If not, then, Mr. McConkey, do you have anything to add?
No, I do not, sir.
Okay,
So, the question is,
yes,
so the steps, you're saying the steps would have to be on the side then?
No.
To stay
They
within the
cannot
64
extend
feet.
another, you're saying they
Correct.
would not be allowed, the steps would not be allowed to be 12 or 2 feet extra.
No.
right,
2 to 3
we,
feet.
okay, so what we can't determine here is whether a step is even needed, because if the foundation of the house is close to, you might just have a landing pad and that might be sufficient
Yeah.
riser. We can't speak it, but if a step is necessary, they can't extend it toward the lake.
Okay.
Whatever they build can be no closer than 64.6 feet.
Including the step.
Yes,
Whatever they build.
Besides-
yes.
Okay, so if that's the case and we don't have any things, then we have a motion to close the public hearing.
So moved.
Seconded.
Okay, so Doug's moved, all in favor of closing the public hearing?
Aye.
Aye.
I guess actually
Aye.
that's my responsibility, but it's fine, we're in agreement. Okay, so now we will begin deliberation. Five criteria, okay, so. The,
Are you gonna go over Drew, the marks, 5 criteria, go over that step by step, and then let me know
Yes.
what
yes, we're going over the 5 criteria right now.
open.
I was just pulling out, it may be, we will either edit or simply accept the criteria as they're submitted in the application. So variance will not be contrary to the public interest because many of the homes in the subdivision predate zoning and many homes construed prior to the enactment of the ordinance are simply similarly located in violation of this provision. In violation of, I'm gonna change,
Yeah.
the setbacks.
I would just say are similarly located.
Okay, are solely located, okay.
And Lou's in violation?
Yes,
Yeah.
Yeah, and just
from
period.
our stuff.
Yeah, just,
The proposed location of the home is a compromise nearly meeting town setbacks and maintaining a reasonable buffer from the water. The proposed construction will not alter the essential character of the neighborhood and will not threaten the health, safety, or general welfare of the public. We can consider, that together with, normally we consider these two, 1 and 2 together. The spirit of the ordinance would be observed because the Madison zoning ordinance permits variances to be granted. Zoning preamble states that the purpose of the ordinance is to promote the health, safety, and welfare of the inhabitants. The proposed home construction is modest in nature and is nearly the same footprint that the Madison zoning board granted the variance back in November 15, 2005. The variance requested today will not alter the essential character of the neighborhood and will not threaten the life, safety, and general welfare. Okay, and the unique characteristic of the property, in this case, is that the building envelope
Does not support.
cannot support a
Reasonable home.
reasonable home. And the board prefers to meet the setback from the lake over the setback from the road. Okay, so granting the variance, any comments on that, is that adequate?
That's
That
not,
sounds good.
Okay. The test for I'd say granting the variance would do substantial justice because any loss to the individual which is not outweighed by gain to the general public is an injustice. So the owner proposes to construct a new home, deck, driveway, and a septic system. The owner's development is mindful of both the water and the village of Edelweiss, new septic offset from the roadway, and the village of Edelweiss is mindful of the water and the village of Edelweiss's septic offset. What is that?
should be an Edelweiss, it should have a
Minimum
punctuation mark.
setback.
It's Village of Edelweiss's new
Yeah,
setback.
what is, do they have, what is, okay.
Oh, what's their septic offset?
Yeah, 25 feet from the road, Mr.
I believe it is. They have an internal setback that's, the state standard is 10 feet. And I believe they have a further setback, so that's what we were following.
Do we, it's interesting.
It might
I
just be
mean,
in their
they-
bylaws. They just updated it a while back because they weren't sure on a lot of their streets where their water lines were.
Yeah, okay, well, that's an interesting question, perhaps for the town, because I don't know that they can make a change to the zoning ordinance without it being approved by the town, right? Because they have a separate section in the zoning ordinance, but those things have to be lined up to see.
I would imagine they could make it more restrictive than the town. They just can't make it any less restrictive.
Right,
Oh, I see what you mean.
yeah, we
Okay.
come kind of above them.
Yeah, so, we say 10, if they say 25, well,
Special
exception.
And they have their own building permit process, if I could
Yeah.
add, so you
Yeah.
have to get their approval after you give them the amount of money for their water and all of that.
Right,
So
yeah,
it
yeah,
comes
I'm
up
just-
under their rules at that point.
Wetland buffers, residential road buffer, therefore,
Well,
there's nothing in ours that's.
well, okay, well, the point though is that, all right, the owner's development is mindful of both water and the village of Edelweiss's septic offset. I'll just take new out. From the roadway, residents driving will note similarly developed property as others in this neighborhood, and the abutting owner will lose primary water view after it's constructed. I suggest substantial justice is done. Substantial justice, there is no gain
So it doesn't say, okay.
to the
It
public
doesn't say the drop to well, it's not,
by denying
distance to the drop to the
the
water.
variance.
Is this a,
Yeah, actually, I probably shouldn't ask Mark that question. Okay, the value of the surrounding properties will not be diminished because the proposed construction will not diminish. As other homes in this neighborhood have undergone similar home builds and construction has not lowered the neighboring. Yeah, okay, so. Any comments on those last two things? Okay. And the fifth one, which is usually the one that causes. Literal enforcement of the provisions of the ordinance would result in unnecessary hardship.
Yes.
The lot is narrow at the roadway and shallow on the west side. The eastern boundary is longer and is bordered in the rear by the channel. The resulting
Eclectic,
eclectic shape, that's,
that's correct.
It is, you could say eccentric,
um,
same thing.
yeah,
In
shaped
this-
zoning envelope would only permit an 8x40 trailer or a 12x18 tiny home to be constructed inside without zoning relief. Instead, we have proposed a more traditional building configuration, 660 square feet Ford home, which is very small, with an outside deck. The proposed home is, there's an error there.
Yeah, that says
Correct, it's
69.4.
We'll say 75 feet from the water, far greater than is required by state shoreline standard of 50 feet, and only, and take that out, it is meeting the 75-foot setback. The open deck is 64.6 feet from the water,
Short by 11 point.
You're gonna
No.
give me this,
Or
right,
10
Drew,
point
because
four.
I've
Yeah,
lost you.
I'll give
You're
it.
kind of mumbling
Yeah,
over there.
I'll type this up for you and send it in
I've
the
got,
morning.
I've got most of it, just to this point.
Yeah, but I'll, as a backup, I'll type it up and send it to you tomorrow. Idlewild setback of 75 feet. The proposed home will be
49.9.
49.9 feet from the center line of the road, where 65 feet is required. There are several homes on Little Loop that are closer than 75 feet to the water, and at least 4 homes on the road that are closer to the center line than what we're requesting relief. The approved septic system meets both state and Idlewild setback requirements. Okay, so, the point is that the unique characteristics, of the property, well, as you mentioned, don't allow
Traditional.
normal setbacks. So the proposed use is reasonable. I don't think, well, we might as well read it since it's here. Use without compliance with minimum lot size. Yeah, so, yeah, we're permitted, yes, there's basically the small lots are grandfathered in so long as sufficient off-street parking for any proposed use is provided within the property boundaries. This lot is non-conforming, the use is residential and has space for the required parking. In addition,
There's a new septic system approval.
yeah, it has and there is
A new se-
a new
system.
septic system approval, and we are,
Meets the shoreland permit.
and it
or-
meets, oh no, and do you have a shoreline?
It's in here, isn't
Yeah,
it?
I believe it is.
Yeah, I thought it was in
yeah,
here.
and the shoreline permit has been issued.
Will be issued once we have final building.
It says will be, but I think
Yeah.
that,
I
It's
think it's
here.
in here,
It's
it
here,
has
yeah.
been.
It's been approved, it's still
Yeah.
there.
right.
Yeah, shoreland impact permit.
Okay, the applicant will, shoreline applicant closing, okay, so these are the criteria. Does anyone feel that he has not met any of the 5 criteria?
No.
Are the 5 board members satisfied that we have met all 5 criteria?
Yes.
With what's been read, yes.
Okay, so then we are in a position to consider a motion, but what kind of conditions do we think we may need to impose?
I don't think we need any.
Move
No,
to-
I
yeah,
think we
that
should
was the,
use the ones that we,
yeah,
there were 2
can you-
conditions from the
Yeah,
previous
let's,
approval.
yeah, move to grant
which-
the variances as specified
On the plan.
on the plan. With the conditions that. Okay, I think we should probably discuss briefly, just for the formality, the applications for a deck. In principle, we can specify that it has to be a patio. Does anyone?
That it has to be what? I'm
We,
sorry?
just simply can't, because we had a request that we consider 2 things. One is that the deck not be permitted, but a patio be required. The other was that we, don't have a driveway on the west side of the lot. Does anyone feel that let's discuss the application is for a deck.
Yes.
If we feel that the deck meets the 5 criteria, does anyone feel there's a need to restrict that to a patio?
No, my only point would be, a patio by my definition is basically a solid surface level at the level of the house. Okay, this deck is actually a non-solid probably, but regardless of the surface, is a surface at the level of the house, at the base level of the house. This is not a raised deck, other than being supported. Even if you were to build a patio, it would need support on that 3-foot corner.
Well, you could argue that a
Because you're not gonna have
patio.
a patio that kind of.
Well, there's a little bit of a definition on patio.
Mhm.
For most of us, a patio would be something like poured concrete
Right.
on the ground
Yeah,
or sand,
Yes.
over
Agreed.
rock on the ground, as opposed to the deck is level with the floor of the house. That's the
but I would
distinction.
expect a patio to be level. You wouldn't have it dropping 3
No,
feet.
nobody's
Absolutely.
saying it wouldn't
So it
be.
would still have a raised, whether it was, it would still
No.
be supported,
No.
or
no,
you dig
You
it
just
out.
dig
They
the
would-
ground
Or
out.
you dig
to
out.
level
They
the
would-
ground.
Okay,
They would, they would level the ground to
Well,
support
yeah,
it.
or fill it in or whatever
Yeah,
you
you
do,
do
you
whichever,
level the
you
ground.
you
It has to
level.
be
Yeah,
level,
but
yeah.
I'm not even sure why we're talking about this, because
Okay.
there's no request
enough.
to
No.
even, so
Fair
I
enough.
get that we wanna discuss that, but there's no application for a patio, so we don't really have any specifics as to what it would be. I'm not in a position to dictate, as you said, to redefine a project and dictate to the property owner that they should put a patio in
Mm.
vice a deck.
Right.
If decks are permitted in the neighborhood, decks are permitted in town, a deck is what has been
Applied for, yeah.
proposed, and I think that that's what we go with.
What- Yeah,
Make
we go
that-
back to the same principle, we don't need to
Yeah.
redesign the project.
Correct.
If the deck as applied for meets the 5 criteria, we don't need to address it in the conditions.
Correct.
Is there a reason to address the driveway condition?
I don't believe
in
so.
the-
I don't believe so.
I go to the same stipulation in that there is no proposal for a driveway
else?
on that side. I think that's something that the owners could probably discuss with each other and come up with, potentially if there's a real concern on their part, they could come up with their own independent agreement that one would not go in here. I don't feasibly see how you could put a driveway in here because of the distance, yeah, because of the
Agreed.
septic piece of it.
Yeah, you can put it-
It's not, it's not gonna
Not
happen.
feasible. no.
Right.
It's not part of this application at any
And
level.
it's not part of the application in any
Right,
way, shape,
okay.
or form.
No, and it's just, I
Yeah, no,
we
no,
just wanted to
Of course.
address those things that were raised. Okay, so, we go back, you were looking up the wording.
yes, so, the original decision from 2023, said the request for the deck had been granted, substantial justice served by allowing the building, blah, 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 with 2 conditions. The deck be no higher than the level of the first floor, and that the deck may not be enclosed or covered, which would make it impermeable. And I think those things are on the
Mhm.
plan,
Yeah,
so I don't know necessarily that we need to stipulate them. We can
Right.
just say as indicated on the plan.
Well, I think, I see no objection to saying that,
Yeah.
because that,
It was in the last
that
one.
alleviates any
Any question?
Ambiguity.
Any future
any
surprises.
ambiguity, and
Yeah.
if at some point in the future they wanted to put a second.
Screened it in or
secondary deck on it, then they'd have to come back for another variance, because we've specified that it can't do that.
Right.
right.
Right. With the condition that the deck be level with.
No
the-
higher than the level of
Okay.
the first floor.
Be no higher, well, we can just take it off, and no higher than the level of the first floor,
And
and it not be
the
covered.
deck may not be enclosed or covered,
Right.
which would make it impermeable.
Okay. Okay, so then we move to grant the variance as specified on the plan.
Is there a plan number that we should have?
And, well, I specify,
I mean-
I wouldn't say it's specified in the application.
Yeah.
Or do we wanna go ahead and say, no, there's, it's specified in the application, with the condition that the deck be no higher than the level of the first floor, and the deck may not be enclosed or covered.
Yeah, that's fine.
Okay?
Yeah.
Sounds good.
Nothing
Further
else,
comments?
anything else?
No.
Fine.
Okay.
Thank you.
Well, then let's just, I move that.
I second.
Okay, any other questions? Okay. All in favor?
Aye.
Aye.
Okay, so we have granted the variance, with those conditions, so basically it's the same variance you had before. Okay, good.
Setback and deck.
Let me read my formalities here, and then we'll be done with this case. If one wishes to appeal, one must act within 30 days of the date on this notice, day 1 being tomorrow. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth all the grounds in which one bases the appeal. Board members are advised to refrain from any discussion of the appeal with other board members and any parties to the appeal until all further appeal periods have expired. Thank you. Case 2505 is concluded.
Thank you.
Thank you, Mark.
This was more fun than the last meeting.
Yeah,
I can
No doubt.
attest to
thank you
that.
for not
Thank-
discussing editing prior to minute meetings.
Oh, well, we would have to do that next.
You must be a teacher.
No, I'm not a teacher, I'm a very detail-oriented person, much to the chagrin of some folks sometimes, but
Yeah.
having
Thank you,
been
I
in.
didn't expect any difference, but I had to talk. Thank you.
Absolutely.
Yeah.
You're welcome.
And I would encourage you that if you'd like to put a deck on your house, to create the application.
Oh, thank you.
Thanks.
Thanks.
Yeah.
Okay,
I'll
so
take that letter back.
you'll
The
take,
letter?
yes, understood.
Yeah.
Let me,
That
yes.
handwritten letter, take it, put it back in here just
Yeah.
because I don't want it. I'm glad you didn't bring it up, thank you.
No,
But I
it's
didn't know what to
unreasonable.
do, I didn't
Yeah,
know.
no, well,
In case it came up, I wanted to be
if it had
prepared.
come up, I could have addressed it.
Yep, that's why I wanted to be prepared.
Right. Okay, so
Minutes.
we have two sets, actually three
Three.
sets of minutes to.
Three?
Well,
Well-
I only gave them to,
Sharon and I
I've only got
have
two.
a special meeting that
Ah.
when we, denied a rehearing.
So before we go further on that,
Yeah,
we should actually all have 3 sets of meetings, because I checked with the lawyers about this, and they said that any member of this board is eligible to comment on the meeting minutes and vote on them, but they did not have to necessarily be present at the
Oh.
meeting. If what they're voting on is that they accept this content to be,
yeah, which is good because George has left the board and that would leave Sharon and I, and by law, we have to have 3 votes in order to approve. So,
so yes. And you can comment them, I mean, there's typographical errors and those kinds of things that, I mean, you would probably not comment necessarily on the opinions of them or those kinds of things if you weren't here, but
No.
you can still vote on them. Which I thought was interesting.
Yes.
I did ask them, so.
okay, so, all right, so let's just take them in order, which will make it easier probably, because
Oldest.
the longest one is first, and we'll just pick up pace as we go through it. Let me ask an easier question since we're still early in the day.
22.
We did come up with a wrinkle in our recent procedural change.
Oh.
Remember, we changed our procedure for the purpose of allowing an electronic submission of an appeal. This month, we had a very unusual situation in that the 30th day of the appeal fell on a Friday when the office was closed. And so the appeal came in on Monday, the 18th, observably 3 days late, but because the office was closed on the 30th day and our procedure only specified that we're allowed to. And the normal definition in the court's procedures, which expands on RSA 677-2, is that it defines 30 days as beginning, as I just read, on the day after the action. And if the 30th day is on a weekend or a holiday, then
It goes to the next
it
business
automatically
day.
goes to the next business day.
Right.
So we can say, well, okay, that's just the way it is. If in another case, it's, the 30th day is on a Friday and the office is closed, well, then they have till Monday, end of business. That would be a natural thing. And we can just make a footnote,
Yeah.
to say that's the way the court does it, and we don't have to change our procedure. Or we can change the procedure to say more restrictively that if Friday is the 30th day when, or if the 30th day falls on a day the office is closed, then electronic submission must be made by the end of the 30th day.
That's typically what
The
he has
29th.
done,
29.
is email me And I told him that before we accepted this, I couldn't accept electronically, and he FedExed the package to my home on the day it was due. But this case was not that way, that's why I was very,
Well, this case is not that way because we just approved the change, you
and
know.
I got his FedEx today from Monday.
Yeah, well, I mean, you know, so the point is that we think that that appeal made it, but the question is the ambiguity. So the question is, how does the board feel about that? Would you prefer?
The next business day. Now, if that Monday was a holiday, for instance, it would be the Tuesday, because the office is always closed on a Friday, as we know.
Right,
And say Monday is Labor Day, so the Friday and the Monday are not working days.
and neither are the weekend days.
Right, nor are the
and
weekends, so
Friday
it
is
would
not
come in
either,
on
so
the
it would
next
just-
working, just like a bank,
Right,
you know, just the same as
Right.
banking and post offices. Except they're not closed on Fridays, but you know what I mean. It's the next business day after that.
well, so.
What is the planning
So are you arguing that our procedure is clear enough as it is?
I would say yes.
Yeah, I would too.
What does the
Well,
planning
yeah,
board
what
do,
do you
Mark?
guys do?
Nobody appeals our decision.
You have a policy about it.
It doesn't happen enough that, you either that or change it to 29 days.
And so,
No,
No, because
Still
that
can
could
fall
still
on
be a
Friday.
Friday.
we don't have that freedom to
No.
change it to 29
And it could
days.
still be a
Oh, is
Friday.
it RSA?
Yes, it's
Oh, okay.
RSA,
Yeah,
yeah.
yeah, and in fact, I think there was just,
So the only reasonable approach would be
Next business day.
the next business day.
yeah, and so just a footnote that says
Whatever
if the
that is.
30th day happens to be a non-working day,
Whatever that means.
the appeal must be accepted by, or received by the next working day or next business day.
Business day.
Next business day.
Business
Okay,
day.
yeah, we just put a footnote in to clarify.
Or is it
because
non-business
that-
day?
That, I don't think that's not a problem, is it, Kate? Just
What
put
do you want me
a,
to
just put a footnote into the procedure that just says,
if,
in the event the 30th day
Falls
Is a
on
non-business
is a
day.
non-business day, it
goes to the
automatically goes to
Defaults.
the next business day.
Yeah.
And that's
That's
that's what the court procedure says. So since
Yeah.
the court procedure says that,
Yeah.
we're
Why
just,
argue?
we're in compliance with standard procedure. I don't think we need
Right.
to say, I don't think we need to,
Make it any more.
right. In other words, we're not changing our procedure. And if we're not
Mm.
changing our procedure, we don't need to read it 3 times and make a
Right.
change. Right, if we're
Right.
simply being
Clarifying.
consistent and
Yeah.
clarifying.
So you just want me
that
to
we-
add that like underneath and?
Yeah,
Yeah,
in the
just
fo-
add
in the
it- yeah,
footnotes
just
of
add
the
it as a
page or
footnote.
something?
Yeah,
Yeah.
yeah.
Yeah, but they don't appeal to us, they appeal to the court.
Oh, that's
We don't get,
true.
they don't give us a second chance.
Okay,
Because
so
we're
let's,
always
Do you
right.
want a second chance?
Lucky you.
okay, so let's
Oh,
look
we
at
on the
these
phone.
minutes,
From
okay,
June?
June 18th to begin with, okay?
She's getting better and better. This is getting better and better, because
Yes.
I don't have a,
I don't even remember when I did these.
Well,
I don't have a
I
typo
put
on
that in.
page 6.
well, that's all right, but the reality is, no, these were a nightmare for Kate, I can verify,
Oh my
because
God.
I came in and worked with her on this for a little bit.
It was a tough meeting.
Okay, so, does anybody have any, page 1?
Nope,
No,
Page 2?
nope.
Unfortunately, I do have something on page 3, way up at the top.
Yeah.
Vice Chairman Schilling stated there are criteria that the zoning board has read into the record before, comma, contesting the supposition that short-term rentals, contesting
the
The,
supposition.
the supposition
Yeah.
that short-term rentals exist, okay, because it wasn't clear what that meant, but that's,
Okay.
that's the essence of what it meant, okay?
okay.
Okay, so, page 4,
Well, you have a
I
lot.
have a couple of things, yeah. The middle of the page, under number 7,
Yep.
Gentile stated that he wanted to address Attorney Johnson's comments and the argument that the general existence of complaints. So just change refer
To
to
that.
address and
Yep.
to that, okay? And then in the next line, unless, beginning at the end of the second line, just so you can read it,
Unless, yep.
unless there is a similar complaint, unless there's a similar complaint, period.
Strike the word
He,
and.
strike and, he disagrees, and then strike that phrase with that slightly and state that to the argument
So it disagrees.
he disagrees that such arguments can only apply if they relate to a specific
Wait,
property,
whoa, whoa, whoa.
period.
He
Okay,
disagrees
right, and then strike the next.
with that slightly and stated that,
To the argument,
Strike that.
okay,
strike that whole thing.
yep,
He disagrees that such arguments can only apply if they relate to a specific property, period.
yep,
Capitalize, the board reiterates. Okay. And then go down three more lines, begins with non-conforming use to expand, period.
where are we, not bringing,
Yeah, it's
2 lines under New London
yep,
land
to
use.
expand, yep, gotcha.
Okay. Non-conforming use to expand, period.
Yep,
period,
Gentile,
yep,
strike and.
referred, ed instead of refers. And then in the next line, to negative impacts in the neighborhood by similar uses can reasonably be used to justify the, strike authorized,
yep,
limitation of use to, period after extent.
yep,
Okay, and then in the next line, after the middle of the line, the applicability,
where are we, hold on, yep,
okay, the applicability, strike of that statement, the applicability of Police Chief King's report,
Change reference to report,
change reference to report,
reference to read,
and then put a period after the end of the March 2024.
yep,
Strike several and just capitalize violations that were related to short-term rentals, strike,
and then,
and they do, so that it reads, related to short-term rentals provide a general indication of the impact on, instead of in, the neighborhood. Okay?
got it.
At the bottom of the page, unfortunately, the last 2 lines. She further stated that, as the board discussed previously, missing word, as the board,
What?
take strike at, and
strike
She
that.
further stated that the board
take,
discussed
take out that and change it to as.
Yeah, exactly.
as the board, yep, gotcha,
As the board discussed previously, comma, take that out again. It is reasonable to, and then we're gonna insert, limit usage to previous levels so as not to affect the surrounding neighborhood adversely, period. Okay, so that whole sentence reads, she further stated, as the board discussed previously,
it is reasonable.
it is reasonable to
limit
limit usage to previous levels so as not to affect the
You
surrounding.
have to insert the word to after not.
Yeah, you have to insert, yeah, the phrase not and then insert to, yeah.
It is reasonable to limit, not
No.
limit?
No, it is reasonable
To limit,
to limit,
Yeah.
right, that's what I meant.
Usage.
Usage to previous levels,
So as to.
so as not to affect.
So as to not
No,
affect, yeah. that's
So
what
as
I meant.
not to affect.
Right, the not is already there.
Right,
The next, there's no to, the word to
Yeah.
is not in
Oh,
between
gotcha.
not and affect.
yep,
Right.
yep. I'm
There we
like,
go.
yeah.
Just
Okay.
trying to insert that.
right, so then put a period after adversely. And then capitalize leave and take the whatever that is
To.
out.
2.
Yeah, period, leave the rentals at the level at which they had previously existed, maintains, leaving, yeah, maintains as opposed to maintaining.
So that should be, that leave should be changed to leaving.
Yeah.
Yes, I'm sorry, yes, I missed that, yes, leaving the rentals at the level at which they had previously existed maintains their ability to continue their non-conforming use. And strike the next several words, by increased usage, not have, and. Those 6 words can go, but you could add this phrase.
And,
Okay, let me read the sentence the way I think it makes sense. Starting at the end of their ability to continue their non-conforming use and limits their potential adverse
To
impact.
adversely impact.
Limits their
the
potential, yeah,
neighborhood.
to
Yeah.
adversely impact, okay.
potential, what?
Okay, so after conforming use,
limits
and limits
their
their,
potential
to adversely impact the neighborhood.
Not on the, yeah.
Take out the word on.
Take out the word on. And not just the neighborhood, but also town, the town.
Do we even need that?
I don't think
Well,
we do.
not necessarily, but I think that's, she was just saying what you said.
Do
so.
you want me to take it out?
Yeah, that's fine.
Yeah, I'm gonna take it out, because that's just a
Yeah,
run-on. That's-
right, yeah,
doesn't
this
make
is-
sense.
Oh, I
This is
think
one
you
of the problems, and when we're talking,
Mm.
we get verbose, and when you put it on paper, sometimes it doesn't make any sense, but we
And
make
when you're
that
typing
connection.
it, you're just,
Yeah,
Right. So for that sentence, since
Yeah.
I said it,
okay,
and take out, and not just the neighborhood,
where are
but I would leave, or the
Leave
town.
in and not just the neighborhood?
Take it
Yeah,
out,
take
and
Take-
not just the neighborhood, and I would leave in, or the town completely. Because you do wanna
yeah, okay, that's fine.
specify that it's gonna impact
Sure.
not just the neighborhood, but the whole town.
Okay.
Okay.
Anybody else have anything else on page 5 or page 4?
Yeah.
Okay, page 6,
You have,
That's a big
I
one.
have one small thing on page 6,
I have
anybody?
a couple
No, I
small
don't,
things.
I'm sorry, it's just a lot of
Okay.
words on page 6, yeah.
It is a lot of work.
Yeah,
Um,
yeah, at the end of Bill Dempster's first paragraph, rented the property for a year, do you see that from the
Yep.
third? Yeah, rented property for a year as a dwelling unit as non-transient,
Mm.
comma,
I
strike
don't
the
know
and.
that.
Therefore, they have lost their ability to continue
To rent.
to rent on a short-term basis, okay?
Where are you?
Right here,
Oh, okay.
rented the property for a year as a dwelling unit as non-transient, and therefore they have lost their ability to continue to rent,
No and, just therefore,
yeah,
yeah.
Right.
Okay, just up above that,
okay?
it reads property for the entire year, and he also confirmed the same cares, I believe
It's
that
supposed
should
to
be
be
cars.
yeah, that was one I had.
Okay,
Love spell check, it's a word.
Yeah.
Second line down in this next paragraph, it says know whether they are or
Or is.
is that is, it should be.
Yes.
Or is it.
Say that again, Sharon?
The line that starts
Yeah,
with know
know
whether
whether.
they are or is, the word that should be it,
Yeah,
and strike the word is.
gotcha.
He does not know whether they are,
Or is it that, or is
or
it,
is it that, yeah, gotcha.
or
Okay.
actually, we could know whether they are, strike that whole phrase, doing this because of the enforcement action. Does that cover that, or do we?
Or whether that some people, get rid of they are or is that.
yeah, I would say take out whether, just no,
No, not the weather, know
Keep the
whether
weather.
they are,
Get
No,
rid
I
of
was gonna say
everything,
take all
whether,
that out.
whether some
No.
people, just whether some people are
Whether
doing
some
this.
people, that
You
makes sense.
don't need all the stuff between
Whether-
whether and
Okay.
some.
Correct.
okay,
Whether some people are doing this because of the enforcement action.
yeah, that's better, yeah,
Yeah.
that's good.
Couple more lines down, the one that starts with process is running its
Yep.
course. At the
Yep.
very end, the is should be an R.
There are legal
And
arguments.
actually, you could,
Well, wait a minute, where are we?
yep, okay,
The line that starts with
process is
process is running, at the very end, it says there is, it should say there are.
Sorry.
and before that, there, you could strike the and put a period and make the there the beginning of another sentence. This is one of those
Which one?
things, the
Yeah.
sentences just keep running on. At the same line, we're
After a
sharing,
foul of anything, full
there
stop.
are, I was just saying, make there the beginning of a new
Yeah,
sentence.
so anything full stop, there are, yeah.
Mhm.
Yeah.
Yeah.
Legal arguments,
Whether it is enforceable while this process ongoing or something, well, that's a long sentence.
I've got something, what did I write there, can you recognize that?
As to or
Oh,
as?
yeah. Yeah, legal arguments as to whether, as opposed to legal arguments of, replace the of with as to.
Yeah.
Mhm.
We need some punctuation in that sentence, cause it goes on.
Yeah, it goes on and on and on, but I think that's part of the problem we have with the transcription,
Yeah,
is it doesn't
Know when there's a.
know when you
Somebody
stop
pauses.
talking.
yeah, cause you can't actually read that out loud and not
Yeah.
take a breath.
I know, but at some point,
Yeah, I know, where'd you stop?
The only thing I have next is when you go
Okay.
down a couple lines.
Okay, but what I
Oh,
did in order
sorry.
to solve the problem Sharon, or Jennifer just mentioned is at ongoing in that sentence, I put a period, struck the and
I don't
that.
even see where
and
ongoing
put-
is.
Which
So-
Oh, there
Okay,
it
we're
is.
on this, still in the same
Sentence
sentence.
As
Legal
to
are
whether it is enforceable while this process is
It's
ongoing.
Full
Period.
stop, yeah,
I love that you say
Strike
full
and
stop.
that.
yeah, some
And
people
start some people with a capital S.
Did not want to take the
yeah,
risk
that
and he believes
helps,
the
to
evidence
take the risk
before the
and believes he believes
board.
the evidence before the board before. Whoa, hang on,
Okay.
some people did not want to
I don't
take the
think you
risk
need
and
that,
he believes.
I don't think you need that comma.
No, because that was, some people did not want to take the risk and he believes the evidence before the board before,
Try to strike that before.
second before the board was that it had been rented as a short-term rental before and continuing up until June 2024.
Well, and I think what
Period.
they're
That's
trying to
okay.
say is instead of the second before is previously. The
Prior.
stuff that had been before the board previously was that it had been rented as a short-term rental. Because there's too many befores, there's
Yeah.
like 3 different befores.
And they're
in that
meaning
sentence.
slightly different things each time.
Correct.
Yeah,
So I'm
subtly,
taking out that second before, right?
completely, but making the one before the board into previously.
No, you still need that before the board. I would say the one after rental should be previous.
Oh, yeah,
Where are we now?
Some
Too many
people-
The next line down starts with rental
Yeah.
before, that before should be previously.
Okay, so the other before is above, we're fine. right?
no,
No, take the second one out,
That's
before
what
the
I
board
thought,
before,
and then
take
she was
that.
jumping to I'm like, wait a minute, okay. Yep,
so believes the evidence before the board was that it had been rented as a short-term rental previously and continuing up until June 2024.
Period.
Yeah. Further
Okay.
stated that his understanding to extent.
Anything more?
Hang on, he further stated that his understanding is to extent that happened.
is that? to the
Stated that his
extent that-
understanding,
To the extent.
Yes,
To
to
the-
the extent, get rid of that.
Yeah, is to the extent that happened. No, that still doesn't make sense.
because it needs a comma. He further stated that his understanding, to the extent that happened, I don't understand what to the extent that
No, I
happened
don't know what
is.
that means. If he understood it, what did he understand? Is to the extent that happened? You see
I
what I
think
mean?
that they rented
Right,
when they shouldn't have.
right. Prior sentence.
Yeah, I get that. Okay, well, I just think it's weird.
Yeah, I mean, this is, yeah, some of these things are very awkward. Anything else on that page?
Yes. If you go down to the 2 sentences, first sentence says, asked Attorney Johnson.
Yeah,
If he had ever had the conservation, it should be conversation. And the
That's
same with
the
the,
Conversation Commission.
right?
yeah, yeah.
And then the next line right underneath it is the same thing, it
It's like a
says
hysterical
conservation.
society, yeah.
Yeah, spell check's not gonna get that.
No,
I once released notes with Hysterical Society instead of historical.
It's not Kate's problem.
No, that's-
It's not Kate's
It was
fault.
in Newport, Rhode
And
Island.
my wife was there
Oh, it's not
today.
your conservation
My wife is part of the
conversation.
It is my
Historical
problem.
Society.
I was in Newport, Rhode
she
Island.
has both of
And you
us.
speak the Queen's English, and you made that mistake,
Conservation
so.
Yeah.
And then someone else had to read my notes because I wasn't there at the second
The
meeting. And
next
apparently
line
much
underneath
hilarity.
that starts with risks.
Yeah,
And the situation because these all arise out of an administrative,
Yeah.
strike the word of,
they haven't.
and
No,
strike
there
the
isn't
S
an
on
of in there.
appeals.
There is no of.
There is no
I have an of, administrative of
and
appeal.
There's
Oh,
enough.
that of.
Yeah,
Oh.
Yeah, that of,
of.
yeah.
Yeah,
That
I
one.
was with you there.
The
I'm
one
on
we
your
don't
page.
see
that
because
little
it shouldn't
teeny
be
tiny
there.
one.
The one that's not
Little
before is
two-legged one
after.
that's
It's after,
yeah.
right. Add the one that's not there, take out the one that is, and strike the S on appeal.
So we're nearly having fun here, be careful, people, yeah.
Maybe.
That's all I have on that page.
Okay,
I have nothing on the next.
I have nothing on page 7, so then we're on to page 8.
8. I only had
Oh, lots of words,
one,
yeah.
actually 2.
It's your fault, Doug, it starts with a
I
McAllister.
know.
I have,
Yeah, well, yeah,
I didn't even attempt to make,
we don't believe in periods here, it's just,
right.
No,
Yeah, I'm
I
pretty sure
can't
my eyes
breathe.
glazed
Okay,
over
I
as
have-
was
Yeah,
reading
I
this
can't
one.
even
Yeah.
breathe
but
looking at
speaking
this
of
page.
periods, that's exactly where the error is. If you go about 3/4 of the way down the page,
What is the sentence?
Gentile stated that the zoning board,
We
Okay,
need to make
two
some
more.
paragraphs here too, that would help.
You know.
Paragraphs would really help.
Administrative process ends with the ending of all appeal periods,
I have no idea where we
just
are.
Right,
before
there it is.
McAllister.
It's right.
2 lines down
Down
from
this-
that. The administrative process
1, 2,
ends
3, 4,
with the
5.
ending of all the appeal
Oh, way down here.
periods.
12 up from the bottom.
So it should be plural.
Yeah.
I get CLE, oh, that one, the administrative process ends with the ending of all
the appeal periods.
periods,
Period.
yeah.
Just before McAllister
Anything
disagrees.
else on page 8?
I do.
I just
Going
think-
back up to,
Yep.
going back up
Okay.
to 1, 2, 3, 4, 5, 6, 7th, 8th line down. First of all, it just has that period.
Mm-hmm.
Shouldn't it just be by McAllister stated with no that?
McAllister stated,
Right?
No, this, go from that,
yeah.
so Vice Chairman Schilling stated that,
Can I,
yeah, sorry.
before we get,
Sorry, Karen.
McAllister stated that if the applicants had, it says bene,
Oh, yeah,
and it
Oh,
should say
that
bin,
bin.
right? They had beignets, beignets.
yeah, oh, God, yeah, beignet, that sounds good.
Right, I don't have anything more until the sentence that starts with Chairman Schilling.
Yeah, said that the zoning
Should be,
board,
there should be the word said,
that, yeah.
That,
Take out the
said that, yeah, and take out that.
Take one of the that's out,
take them both out.
yeah.
Yeah, take them both out, just should be the
Said
zoning board's
the
original
zoning board,
decision.
yeah.
Page
Anything else?
9?
I have one here which I can't, whether I'm just
Okay.
reading it wrong. It's 1, 2, 3, 4, 5, 6 lines down in the middle. Vice Chairman Schilling stated
Wait,
that-
6 lines down
down
from where?
from the beginning of the paragraph, of the big
Still on
paragraph.
page 8?
I'm still on
Yeah.
page 8, and in the
1,
middle
2,
of it,
3,
it says
4,
Vice
5,
Chairman, second sentence,
6.
Vice
Oh,
Chairman
okay,
Schilling.
it starts with concerned, comma, the owners of
Yes,
abandoned property.
yeah, abandon the property.
Okay.
Okay, Vice Chairman Schilling stated that what Gentile was saying, that because of the situation, is saying.
Should say,
I can't-
is that,
Yeah, exactly, to make sense of it, is that because of the situation, and when you're on going through the process, the
it should be
clock
a
sort
comma
of
after
stops.
situation,
Yeah, and because of the situation, and when
and
you're
when you are on going through the process, the
the
clock sort of stops.
That sounds a bit,
Oh, sorry. Clock sort of stops.
okay.
But it should just be period,
Stops
just
with,
stops.
but sort of
right?
stops with that.
Okay.
Saying
Full
the
stop.
sort of
Stops,
situation
sort of stops,
when you are
period. Take out the
ongoing
with
through the
that.
Yeah.
process, the clock.
So what are we rewording? You guys are doing your own thing and not.
No, no,
We'll
no.
let you know.
We're reading the sentence.
After we hash it out, you know me,
Yeah, still
Okay,
working
so
on it.
let me
I'll
read
be
it
really
out
good
loud.
about
Vice
making sure.
Chair-
Yes,
We don't
I'll
know
make
what the
sure
hell we're
you
doing.
get what we're doing.
Vice Chairman Schilling stated that what Gentile was saying is that because of the situation, and when you're on going through the process, the clock sort of stops. I would get rid of with that
That's
personally,
what we said.
Yes.
yeah.
Okay,
Mhm.
so at the end of that second sentence,
Mhm.
where it says the clock sort of stops,
I would say
make it
stops.
period.
Yeah, and I would say the clock stops.
So you get the
not
sort of
stops.
out, yeah.
Take the sort of out.
I agree,
That's, yeah.
because I don't like that, that doesn't sound very legal if anyone took it to. Anyway,
And also the word ongoing, when you are going through the process, it shouldn't be
Yeah.
ongoing.
you-
just going, yeah,
Going.
yeah, okay,
Strike
that's all I
the
had
on.
on page 8.
Okay. Alrighty. Page 9, I have one thing, which is almost exactly in the center of the page. In fact, it said the bar on the F, whatever, it should be whenever.
What does that sentence start with? What does that line start with?
The
That's how
beginning
I
of the
find
line on the
these.
page.
Because once there is a final decision, be it now or 30 days or whenever else, or whatever
Oh,
else.
whenever.
Yeah.
Okay, I have a couple above it.
In year,
Okay.
where are you?
You've lost me.
Years-
Okay, do you see the draft? You see where the F is in draft?
Yep,
It's right at the center of the F, whatever. It should be whenever.
The line that starts with, because once there is a
Yeah.
final decision,
That's
yeah.
right here.
Be it now or
Yeah.
30
Yeah,
days.
whatever.
or
I just.
whenever, not whatever. It helps her to tell
Yes,
the
yes,
line.
yes.
No.
I didn't get it the first time.
Okay.
Gotcha.
yeah,
On the second line, going back to the top that says were, and what we are doing now,
Is
Yeah.
should
that,
be
Is.
comma, as we are reading,
Yeah.
strike into, intentions into them,
yeah, as we are reading intentions into them.
right?
How about removing the and putting a full stop, we do not have the facts to support
I
it?
don't know where
Put a
you
comma
are.
there.
Keep
Right there.
that same
Same
sentence,
sentence.
intentions into them,
Period.
period, and lose and, we do not have the facts to support
Capitalize
it.
W,
Yeah,
we do not have the facts.
facts to support it, and we can only go, and can only, we don't need we again there. And
Strike
can
the
only
we.
go with the facts that we have in our hands.
Period.
Yeah, full stop. That is where he is coming. Who's he by this point? No, I'm serious, because we've been doing a we up till then.
Well, but we didn't read the last part of it.
McAllister,
McAllister.
that's okay.
Yeah, right,
It's all right.
because it's only a couple
So
sentences.
you can change ma-
Yeah, no, that's fine.
Yeah,
The next line says Chairman Schilling, it should be Vice Chairman
Yes.
Schilling.
Yep.
Chairman full of vice.
Chairman Mao.
The two, 3 lines below that start with pursue a longer rental. Whether it was month to month or a year long,
Or year long, lose a and
or a year
rental.
long, it says rentals, it should just say rental.
That is a rental.
It says rental,
Yeah, there's only,
a
there's
year-long
no S
rental,
there.
comma.
Oh. well,
Year-long
why do I
rental,
have-
comma, is irrelevant. Yeah.
Oh, maybe that's a comma that's supposed to be there.
yeah.
Yes.
Yeah.
That's what it is. I didn't strike an S, I wrote a comma.
Sorry.
My comma squiggled.
Is gotten really a word? I'm sorry, I'm being a Brit.
Is what a really a
Gotten,
word? Yes.
it is,
Yeah,
sorry,
we gotten that.
yeah. I
Yeah,
don't-
it is.
yeah, I
On
don't
this
use
side
it.
of the pond it is.
Yeah, no, I didn't know if it was a written word. I know this is very much a conversational word, don't get me wrong, I'm not trying to be bratty here.
Yeah.
I just didn't know it was actually a written word.
Yeah. Now, how you
know
spell
what
it
you
is another question.
Oh, I'm not going there,
No.
don't go there.
It's spelled correctly. Okay, I'm done with that page.
Okay,
9,
page 10.
I got nothing.
Yeah, I
Wait a
got
minute.
two small things. Go ahead, did you have something?
I did, actually.
Yeah.
At the end of the public meeting notice paragraph, Attorney Johnson waived and procedural issues. I'm guessing it should be any.
Attorney Johnson waived.
Any
Proceed- No,
Any.
waived procedural issues with the mailing.
Just take out the end.
Yep.
Waived
Oh,
procedural
okay,
issues
yeah.
with the mailing, yeah.
He didn't do this.
He's not prone to doing that.
Okay, so then underneath where it says, there's those 3 bolded things, conflict regional waiver. In that paragraph, it starts with Attorney Johnson explained, 2 lines down underneath that. I'll start reading at the end of the second line. He further stated that this is a property strike that the applicant, that this is a property,
Should keep the that.
yeah,
That
that
does
not have a history
history
of short-term rental use before the zoning ordinance changed. Yeah, keep the that, a property that does not have.
Yeah,
Okay, and then a couple more lines down where it says potential to have a short-term rental, period, strike the and, he capitalized. Anything else on page 10? If not,
No.
let's look at page 11. Anybody have anything on page 11?
On the paragraph that says motion by Schilling, seconded by McAllister,
Two of
to
To
uphold
uphold,
the
yep.
zoning board, yep.
yeah. that's
Anything else?
Okay, page 12.
Lots of words.
Ooh,
The very middle of the page, just before where it says August 2022,
Yeah,
it says of, change that to before.
well, wait,
where are we?
The middle of the page,
Yeah, I'm there, but
Yeah.
where?
there's
which,
August,
this
okay.
period of August 2022, it's
So
a period
The sentence
before.
that starts with because it is after the time period, go to the end of that line.
Yeah,
Oh, the very, where are we?
it ends with August 2022, just above Vice Chairman Schilling swore in Bill Dempster.
Because it is
Halfway
after
down.
the
Yep.
time period, yep, go to the end of that,
Yep.
that line
And then
and strike the of
yeah,
and
it's
change it to before.
focused on the time period
before,
before August 2022.
yeah.
And I have one as well.
Go ahead.
Up above that, in
Oh, I-
subparagraph 1. That last,
Who owed what and when?
yes, that,
Yeah,
the end of that paragraph. Ryan Finn and Grace Harrigan, who then they
They.
sold it back. I
I'd
would
just
say
take out
strike
they,
right?
yeah, who then sold it back to Dan Moynihan's. You could not imagine, go
Oh.
back and, like, which Moynihan are you talking about?
Oh, it was extraordinary.
In the next paragraph that starts with Attorney Johnson, insert the word stated,
Where?
right after
After
Attorney
Johnson.
Johnson.
Number two, Attorney Johnson stated
Stated.
the other question.
The other question,
Yeah, gotcha.
strike was he had, and insert regarded a
Yeah.
statement from Dan Moynihan Senior.
Yeah, that makes sense.
You know, I hate to ask this question, this is a fact, it says Daniel Moynihan Senior and Daniel Moynihan the Fourth, father and son, that has to be father and grandson.
They were trying to determine that night.
Yeah, they couldn't figure that
We
one out.
went with what they told us in the
Yes,
end, because
that's what they
Yeah.
said.
they were not clear on the genealogy either.
Right,
Well, okay, the bottom line is it's two distinct people and
Yeah.
they're clearly distinct, so let's not sweat the program,
yeah,
okay?
I'm
Yeah.
not-
Yeah, one was the elder and one was the younger, but
Yeah.
how much younger was
The
a,
senior
Could be
is
like
the
George
father
Foreman.
of the,
Yeah.
of the fourth.
I think,
Senior can't be
the
the
fourth was
father.
the oldest one, he
Well, I
was the
think-
patriarch.
I think,
Senior would be the father of the fourth.
Right,
You're missing a third, but
right.
no, I think he is the third, but he goes by
Senior.
senior.
'Cause maybe-
Because he's the father of the next one.
because maybe the real senior is dead already.
Yeah.
Okay,
Yeah.
yeah, well,
Who cares?
yeah,
Yeah,
that's fine,
but-
okay.
You're right.
We just know there was
We
an
don't
older
worry
So
and
about
a
he's-
it,
young one.
it's father and son and that's
Right.
all we're concerned
Dan
about.
Moynihan, the senior, as opposed to senior maybe.
Okay,
Leave it be.
I just let it be.
Distinguishing
Yes.
type.
okay, at the bottom of the page, I had one in the very last paragraph.
Because Gentile,
Yeah, it starts, because Gentile did not have a copy of Denster's handout, Gentile reiterated from what he understood, strike the is,
Yeah.
that the contention is, strike between and replace it with about. The sale of the property and strike he asked, strike he.
I think you should just put a period at the end of property, strike and make it, he asked, when was the
Okay,
date of the
that's,
sale of the
yes,
property?
that's perfectly fine.
thank you for that.
Yeah,
Yeah,
I think that, did you get that, Kate?
Yep.
yeah,
Okay.
okay. Page 13 then.
God, it's 22, isn't it?
I didn't have anything.
I
I
have
do.
one small one.
I'd just like some
It's in the second paragraph, the second line from February 22nd through all of 2022, off and on short-term rentals into 2023, period. Capitalize the I in it.
Just as a nitpicky thing,
Yeah.
we don't have to tell Kate to capitalize the word after, the letter after the period. I think she's smart enough to do that.
All right.
Well, I think she is too, but I think because we have so many changes that it's best so that
It
she
gives her a
tracks
chance to
and
buy
catch
time.
up. Yeah.
I would love to have some.
Anything else on page
I'm-
13?
Yeah, I got
No.
a couple. I have a
Anything
couple.
on page 13?
Yeah?
Hang on, yes.
Yes,
So forgive me, because I wasn't part of these meetings, so.
no, that's
Okay.
fine.
Yeah.
But if we go up further, so let's see, the line starting with, it's the fourth line down, starts with 2023.
Mhm.
Attorney Johnson stated the cease and desist letters starting going out should be
Started.
We
started.
started, yeah.
Yeah.
And then a few more lines down, the line starts with decision,
Mhm.
that they could not short-term rental
Rent.
Or should be rent.
rent.
Because time matches up.
Isn't it time marches on, not matches up?
Is
Well, I
it
think he's talking
anything?
about
Is
the
there
time-
any need for because anything though?
Well, I think is she's we're talking about that the time matches, the time frame matches up.
Time
too.
frame would
So
be
we
better
could-
then.
Yeah,
Because time, because
because
the,
the
Time marches on,
time
but the
frame,
frame
the time
matches up.
frame
because the time frame.
matches up. The zoning ordinance has changed.
Okay,
Yeah,
and
still
then,
evolved, but.
let's see, in the middle of that paragraph, it's 2 lines below the $2,500,
Yeah,
starts with "and we are."
yeah.
In the middle of the appeals to challenge this, so why should,
They.
They.
then it should be they.
I read right past that. I'm usually
Did
pretty
we
good.
Yeah, me
all?
too.
That's all I had on this page.
Anything else on page 13? Page 14?
I have in the third line down,
We have not eyed.
I think that's supposed
Yes, I
to
got
be
that.
notified if they
No
were aware?
idea, we have no idea.
Okay.
Oh, is that what it
Yes.
is?
Idea, yep.
IDE,
right.
add an A, all right. I thought we were in the middle of March, the
Yeah.
eyes.
Yeah, me too, and I could have sworn it was June. Yeah.
Anything else on page 14? Excellent, okay, page 15.
Halfway down the big paragraph, starts with milestone letter is the line, about three
Milestone
quarters of the way down.
and a realtor.
It's fourth from the, milestone letter, it says they, the applicants, were always contemplating.
Oh, yeah.
It should say, they should be replaced with that.
Yeah.
Yeah.
Milestone letter that the applicants were.
Anything
Oh.
else in 15?
Just up in that paragraph, the sentence beginning with rentals, it's the fifth, sixth sentence down.
Yep.
He explained that the applicant started looking for a property in 2021 and started working with a lender, milestone and a realtor, comma, there doesn't need to be a comma there. A lender, milestone, comma, and a
And-
realtor to find areas.
So the
So it should
the
be,
comma should
there isn't,
move
Yeah.
after lender to milestone.
Yep.
and away
remove
from
the
our
one from
realtor.
realtor.
Yeah, then it runs, you can actually, because they found a lender, milestone, and a realtor
Realtor.
to find areas.
Man, I felt bad for those people with their realtor.
Oh,
Yeah. I would be very ticked off with a realtor, but that's another story. Okay,
so we on page 16 now?
we are.
16. I have a couple, middle of the page. The first one is on the line that starts with, because of the poorly drained soils.
Yep,
Yeah.
This is from the road, from the road and abutting property damage,
Drainage.
drainage. Next one should say, it says abutters.
collect on the road.
It should say water collects on the road. The
Yeah.
abutters don't collect on the road.
They could,
I
for
mean,
all
they
we
might,
know, yeah.
Or maybe it's butter collects on the road.
Right? The butter collects on the road.
Maybe it's abutters collect their water.
This is true.
It could be a lot of things, though. The water could collect
Two
above us.
lines down that start with purely drainage.
Yeah.
And per the plan, comma,
that's weird.
strike he and make it it. It does not, we're talking about the water, not him. He
further
leaves his
states-
property.
Yeah, stated that there is no vernal stream or pools, and this is purely drainage. And per the plan, does not even leave his property.
So
And
wait a
just
minute,
say
so in that
subject.
statement, in that sentence you just read, he further stated, strike the.
Yeah,
Where are you?
He
Oh,
stated
the next
there
line
is-
down at the end.
Yeah.
he further stated there is no vernal stream.
Should be, that there is?
That the
No,
blue
just
line
there
on the
is.
plan, I don't know where
No,
you
we're
are.
still above that. Where you
Oh,
had
he
a
further
buffer,
stated, there is no vernal stream or
Yeah.
pools.
Right.
Take out
Strike the word
the,
and is, yeah, this is purely drainage per
or
the
you could
plan.
put that.
Put a comma after pools.
Yeah, and he does not, and
There
it
should be a before and end.
just sinks into the ground. Yeah. Just to be nitpicky, we're up near the top of the page, Vice Chairman Schilling stated that Lemieux was sworn in at the May 21, blah, 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 continuation of that hearing. So does he, you don't need to put, so he does not, so does not need, you just don't need a he there.
Continuation of that hearing and does not need to be sworn
Yeah,
in
he just
again.
needs, I mean, that's.
Take out
picky.
so he
Yeah.
and replace it with and.
Yeah. I'm
Right,
not gonna
so
get to-
on the line that starts with photos presented,
Yep,
it says the to, those words should be reversed. It should say to the board.
yeah.
And a little bit further down that line, it says is not poorly drained soils, it should just be soil.
Uh-huh.
Right?
Okay, page 17.
In the paragraph that starts with Vice Chairman Schilling at the top of the page, the second line, it says that these can be based off the applicant's application if they are acceptable to the board. Then it says Vice Chairman Schilling.
Double vice,
I'm a double vice.
yeah.
We gotta find another way to, cause applicant's application,
That's funky, isn't it?
yeah.
What?
We continue to refer to an applicant's application as
But they
applicant's
are-
application,
yeah.
but there's gotta be another way, cause it sounds.
Because they're already
You
applicants
just
by
simply
virtue.
say the application.
Yeah,
Or
that's
the
all.
Just say the
application.
application.
Just put, get rid of the applicants.
Yeah.
Okay, go
Yeah.
back
Put
and get
through,
rid of
through the
two
applicant.
lines, those 2 lines. The one that starts with that these can be based off the application, and then Chairman Schilling and the board went through the application. We
Right.
know it's the applicant's
Yeah.
application.
Right,
Because who else would it be?
and one more. And instructed Young, land use board administrator, comma,
Yeah,
There you go. She can
that
copy
she
the
can
5
copy the
criteria.
5 criteria.
yes.
It should say from the application, not
Yes.
from the applicants.
Yeah. Doing
I have nothing on 18 or 19,
Okay, then page 18. Boy, we're getting right down to it.
right?
Which is good.
I was
We still
okay
have
with
2
that.
more to do,
Well, yeah,
but they're good.
They're-
for-
they're
Well, we
shorter.
only have 1 copy, we don't have all of them.
Yeah, you have to do it, we don't.
Yes.
Right. I have nothing on 18.
No.
Good, I don't either.
Anything on 19?
I don't have anything on that.
Me either.
Okay.
Anything on 20?
No.
I only have, where it says subparagraph B, owing to those special conditions,
Mm.
there's a blank line right after that,
Oh.
that has to be
Oh, yeah.
removed.
It's in there, yeah.
Okay,
I don't know if for consistency's sake, like where you have, when you go down to 2, it says the variance will not be contrary to the public interest because, and then the paragraph starts right after that.
Should be a
If you
gap.
go to B, if you go to C, there's a
Oh.
space between because and in determining. I
Yeah,
don't know
it
if you wanna
seems to be
remove that.
It seems to be inconsistent across.
The setting out,
Yeah, it's the paragraph.
Paragraph C,
Yeah.
see how there's there's a space between
the
the
bold,
bold and where you start in determining
Oh,
the
I can
placement.
remove it and make it all underneath it.
Right, and then the same thing in paragraph B, after because, there's an extra, you can remove that.
yeah,
I
and
would
number
leave it-
5 is the same. And you go through 2 and then on page 18,
Yep,
3 and 4 are straight into the non-bold and 5 has a paragraph
an extra
space,
line.
yeah. It's just setting out.
Okay, page 21, anything?
Yep.
Just the same with that font, yeah.
Okay, Rich, what'd you have?
Very last paragraph.
Yeah.
Vice Chairman Schilling, reopen case 2502 to address the concerns made by the
By.
MU.
Yeah, not B. That's all
Oh,
I
my
got.
goodness.
That's all I got.
22,
I got nothing on 22, and I got nothing on 23.
okay, excellent, okay.
One down.
Someone.
I make a motion that we approve the meeting minutes of June 18th as amended for typographical errors.
Second,
All in favor?
Aye.
aye.
Okay, alrighty, we're
Approved.
approved. Okay, so July 16th, this one's only 13 pages long, which is,
Should take us half as much time, is that what you're saying?
yeah, at least, yeah.
Since-
Okay, so, yeah, yeah.
Ouch.
Okay, so I only have one thing on the first page, and that's in the middle of the long paragraph under elevation of alternates, where it says Mr. Franklin was also on the phone. See that?
Yeah.
Okay, right underneath where it says Mr. Franklin, a 4-member board
Board.
present
Yep.
tonight. B.O., yeah, okay.
I have 2 more on the page. If you
Okay.
go back up to the second line of that paragraph, was on the public notice, where it said comma, so as long as I think it just needs to remove as, so long as the zoning board of adjustment hears all the cases. Strike as. And then on the line that starts with prohibited action, at the very end of that, Mr. Franklin via telephone, there's 2 periods, strike 1. Then, a couple more lines after that, that starts with board, and he introduced himself as chairman. Sharon Schilling, Vice Chair, Doug McAllister, and George Rao, period. Should be a period after George Rao. That's all I got.
Okay, page 2. Anything, I didn't have anything on
Under
page 2.
the second paragraph, under public meeting notice, Chairman Gentile stated that the ZBA was waiting on information, should be had been waiting on information. In the next paragraph down, previously, it starts with previously to the ZBA. At the very end of that line, Franklin to provide to the ZBA, it says a 1 year of rental history, take out the A, just say 1 year of rental history. The next to the last sentence in that paragraph starts with rentals, period. Attorney Johnson further insert the word stated. Could probably take out further, but
Yeah,
Take Attorney Johnson explained.
no,
if Attorney Johnson's, just take out further and say stated.
the family uses the property.
In the last big paragraph, Chairman Gentile asked the ZBA, if you go to the line that starts with Johnson, he or Franklin could summarize. After the word, after Johnson, put if he or Franklin could summarize the sequence of events. And then move the word where it says as to when was the property chosen, it should say when the property was chosen. And when the loan application was made.
Yep.
Otherwise you gotta put question mark
Still on page 2.
there. Yeah,
We're just ending page 2.
Did you put an if in there?
Yep.
Yes.
All right.
Okay, top of page 3, affect should be effect. Very first line.
Chairman Gentile asked what in effect.
You don't need those commas there either. Chairman Gentile asked what in effect was the earliest date. You don't need to comma that.
Yeah, neither one of those.
In the,
I'm sorry, at
Go ahead.
the end of that line where it says was February 28, 2022, question mark, it should say was it February 28th.
Right.
okay, I have, under the middle of the page where, let's see, 4 paragraphs down, says Franklin made a statement.
Mhm.
Okay, so at the end of that, period at end of 2021,
And I struck looking for a property.
and then strike looking for a property.
Yeah, that's what I did.
Yep, okay, and then in the next line, at the end, he further explained that they needed to rent the property to cover some of the costs, but not to make a profit.
Did he use the word cover or supplement?
I don't
He
know,
said
but
supplement.
You can go either
If
way.
he used supplement though, but if he specifically
Yeah.
used the word supplement,
well, okay, then that's
I think
fine.
we should
Yeah,
Yep.
leave that.
Yes.
because it's, yeah.
Okay,
That,
if
that's
he
what,
used it, well, that's right, it's an incorrect word, but if he said it,
If
we
he
should-
said it,
that's,
yeah.
you know.
if we go back up to the Bill Dempster paragraph, on the line that starts with violations,
Yeah,
strike at that went through, those 3 words.
and that, the town, you can
Yeah.
get, you don't have to have that there, and the town of Madison, do you? You
You
don't
don't
need that.
have that?
Oh, seems like there's a lot of that.
Before, so.
And then on the line that starts with warranty deed was signed on April 26th. At the very end of that line, the word mortgage should just be one, mortgage, strike
Not
the S.
mortgagee, it's an E.
Or oh, it's an E.
Yeah.
See, I can't read it once I strike it out.
That makes sense.
Okay, so,
Yeah.
I'm done with the
done with
page.
page 3, anybody else?
Yeah.
Okay, on to page 4. No, I don't have anything on page.
I have 3 on page 4. Up the top, Dempster explained that he has
Yeah,
read
that
on court.
was-
If you go down to the line that starts with stated that the dates are where they are and that the applicant did, strike the word to. Should just say did a lot of financial work.
Right.
Do you know where I'm talking about?
Yeah.
You got it? Okay. And then go down to the paragraph that starts after hearing all testimony. At the very end of that line, strike the
Public,
word on.
Yep.
Is that what, it says public,
Says
Where?
public M.
oh, public M, strike
Yeah.
whatever that is.
It's-
On the next line, meeting, and that, it says they board, it should be the board. That's all I got on that page.
Okay, page 5. I have something down at the bottom, does anybody think up the top?
I
Yeah.
don't, yeah, I just have motion should be motion.
Where?
Motion, where's motion?
I see.
Chairman Gentile, down
Oh.
the bottom where it says, the last paragraph, Chairman Gentile stated that after consultation, the next line after that, given
Oh,
the
yeah.
strength of the applicant's motion, should say
Motrin, the way
motion.
we were
It
feeling.
sounds like a, yeah, it sounds like.
And I don't think it needs to
Truck.
be capitalized.
Where's that?
Right here.
Well, it's a motion for a hearing, it is
Oh, mo-
capitalized, because
It's
it's
a
a
mo-
form.
Oh, motion for
Yeah,
a hearing, yeah, yeah.
I think Motrin was appropriate.
Okay, and then the next sentence where it says Chairman Gentile explained that, that's a repeat of the previous paragraph. You could take from Chairman Gentile all the way down to where it says Chairman Gentile, take that whole section out, so that
Gone
it
through
best
the
says.
appeal, draft the response, blah, 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 blah.
Yeah,
Okay.
because it says Gentile explained that he has gone through the appeal and drafted a response to it and will take it in 4 steps. Okay, we've already
So-
stated the next thing, and then it should be Chairman Gentile instead of Chairman Gentile.
Wait, what
This-
are we taking out?
This.
Yeah,
This,
what are we
this
taking?
whole sentence?
Oh, wait.
No,
Chairman,
that, all the way down to here, because it's, that's a duplication from what I
You're
just
in
said
the
up
third
here.
line from the bottom, Drew, is that what you're talking?
all the way down to applicant, that's in the third line from the bottom.
Yeah. Mhm.
So take out that whole paragraph.
Well, not the whole paragraph, but yeah, where it
It's-
starts at Chairman Gentile and then the next 4 lines.
Starts on the third line, says Chairman Gentile.
then
Explain
take
that
out-
pursuant.
Take out the line starts with explain, take out the line starts with motion identify, time of the public hearings, and within the 30-day appeal. Those lines all go all the way up to the word applicant.
Right,
Got it.
because we already stated,
Did all that, yeah.
And he's only one man.
yeah. Okay.
So
And
chairman instead of
Chairman,
man.
yeah, not chairman.
Chairman.
Okay,
Further up on the page.
okay,
um,
further up on the page.
Just above approval of draft minutes, sentence starts Chairman Gentile stated. That's the second line. Minutes of April 26th, April 16th, 2025, and I would say strike the word the.
Okay, anything else? Okay, page 6. And the reality is that in the future, we're gonna, because these cases, are so, we're not gonna have long minutes like this
No,
all the time.
or I'm gonna quit.
Heard this story
Right.
before.
Yeah.
Promise?
So,
Is that a promise?
We've got it on
No, it's
tape.
not a promise.
It's an expectation.
It's a hope.
It's a dream.
It's fingers crossed.
No, it's more
More of a
substantial
nightmare.
than just a dream, but it's not a promise.
It's called a nightmare.
Right at the top of the page, Chairman Gentile read the following aloud and explained to the board, so you can explain
Where?
he was going to.
Which page?
Top,
Top-
page 6.
Top of page
Top of
6,
six.
Chairman Gentile strike
first.
explained he was going
Ah.
to. Chairman Gentile read the following aloud.
Yeah, got it.
Okay.
Yeah.
And then, in the paragraph, it says Chairman Gentile explained that this is one option. The end of that paragraph, it should say, rehear the case, rehear, so strike, and he further stated that these are the board's options.
So it
Yeah,
should
the-
just say, they think the ZBA should rehear
The
the
case.
case, and then strike everything else.
Yeah.
I have one in subparagraph A. It says Vertex Town in Freedom, it
Yeah.
should say Tower.
Yes, I had that.
There's no place, No Vertex Town. But there is a Vertex Tower. In paragraph D, the second line from the bottom, location is allowed as,
Permitted.
it should just be permitted, take out the A, as a permitted pursuant. That's all I have.
Subparagraph C, very end. It says
These are
further no.
quoted these are, just so you know, these are quoted things from his application, so.
Yeah.
Okay. It says further no information was provided.
Further, comma, no information was provided regarding the RF coverage from the Vertex site in the 1900 megahertz band.
Does it need all ... after that?
Well, as Kate said, this is,
From
There.
He
his,
didn't read the
Okay.
whole paragraph, you only read part of it from Attorney Springer's rebuttal.
right,
That's why I did the ... because you only went so far.
Okay,
okay, so did you copy this from his stuff, or did you?
I did.
Okay, all right. Okay,
Yep. We're
page.
changing things that he's,
Yeah, I know, the little, is there anything else? Well, obvious things like, town, Vertex Tower, that's okay to change,
Yep.
because,
Yeah.
that helps understand what's
yeah.
going on. Page 7,
no,
Nothing.
well, the only comment I have is that subparagraph I, you lost the indentation.
No
Oh,
G.
yeah.
There's no H either.
H,
There's
there
no
was
H.
no H,
usually there's no I and there's an
there was
H.
no H whatsoever on his.
But there was an I.
Yep,
That's strange.
it was very strange, that's why I called it out and moved it over, because there was no H.
He probably ripped it out and didn't forget to
No
reattach
H.
it, right?
yeah,
Very
well,
strange.
okay, I mean,
That's
those
why I
kinds
made
of,
the I and moved it over,
Oh, yeah.
because there is no H.
that's fine, that's
I was
okay.
trying to show that there's no H.
Well, you could, in order to make the record clear, you could put an H in and say, missing in the original. Because
Yeah.
otherwise, somebody will wonder whether we missed it,
We might be.
Like, where's H? They're
Yeah.
gonna wonder where's H. So put in an H and say,
missing in the
Missing
original.
from attorney,
Yeah,
right, missing from Attorney Sullivan's
Not
input.
supplied.
Or
Submission.
not supplied,
Yeah.
right, not,
Yeah,
um,
yeah.
Not
Yeah, just put
supplied
not,
by
I like
Attorney
not supplied. I
not
just think
supplied by
that's,
Attorney Sullivan.
yeah, that's good.
that's fine.
Yeah, I do have one.
Do
one
we,
thing on here.
sorry, go ahead.
That's okay. Let's see. The paragraph, about 2/3 of the way down, starts with Chairman Gentile.
Yep.
Towards the end of that, the last sentence reads, Chairman Gentile stated, strike the word the.
That.
it'll just be he will go on to
Yes.
the other points, and then the
Okay.
board can consider the whole issue.
Page 7, second paragraph, the last
The line that
paragraph.
starts with as this moment,
Okay.
comma, but gave, at the end, where it says Chairman Gentile
Yep.
stated, take the word the
Yep,
out.
gotcha.
Just as a point, because Kate's just said, this is all we don't stay at anywhere at the beginning of this bold, that this is all from, where we're saying not supplied, we aren't actually saying it has been supplied by them in the first place.
Would
I
it-
think if
We're
you
just-
go
Would it be
back,
wise
Quoted
to,
it,
it
would it-
says Chairman Gentile read the following
I
aloud.
quoted it.
But
yes,
from
you
where?
did, right, page 6,
Okay,
middle of
okay,
it. But I would suggest that anything you quote is italicized.
or just put quote, the word quote,
Yeah.
yeah,
Well, there are
something like
quotes,
that.
certain findings of fact
Right,
set
there.
forth in the
Yeah,
notice of
fair enough.
I
decision.
would
And it
italicize.
said, ask the board if they wanted to review Attorney Springer's 8 points. Rouse stated yes, as well as Schilling, and then he read the following aloud.
Okay.
So these are the 8
It's
points.
covered, yeah, all right, thanks.
Okay, so are we on to page 8?
8,
Yep.
I got nothing.
I'm guessing,
Oh, wait, I did.
Yeah, I do have one minor
Yeah.
thing, what'd you say, Rich?
top line, University of, should be
Southern.
Southern.
Southerly
I
Alabama.
love that,
It's southerly.
yeah, it is southerly, yeah. That's very
And,
cute.
and that line way at the bottom where it says Chairman Gentile sticking out,
Yeah.
read aloud the ZBA's responses to points 3 to 9, missing the word
Oh, the
points.
word points. And I don't, you have to go back up on point 8, the second line. it says, and would not create an unnecessary hardship. I think that's supposed to be, would create an unnecessary hardship.
I'll change it.
The decision states that the project would significantly impact the rural nature of the area. Oh, no, never mind, he's right,
Yeah, I
this is
think that
his,
I don't
this
wanna
is his.
change-
No, I know, this is him, I
This is
got
his
confused.
pitch, yeah.
Yeah,
Yeah, no, I don't.
What is happening with this case?
Probably gonna go to
It's
He
in court.
filed it in federal court.
I thought
Yeah.
so, yeah.
next page, anybody got anything else?
On
Page
the-
9?
Yeah, I have one minor thing on page 9, if I can read what I said. It's in the big paragraph in the center,
Yeah.
where it says disagreement with regard to the applicant.
Yep.
Okay, the next line down, which says erroneous, the board's decision has procedural or legal errors.
Yeah,
Not
not
erroneous or legal errors. It's
Procedural.
or legal errors.
Yeah,
I have one further up in that paragraph. The line that starts with serious error on the board's part.
Mhm.
Says Chairman Gentile stated that he does not have permission
Does not.
from, take the word from out, he does not have permission. He does have permission to say that he does not believe there are grounds.
Does have permission.
That feels weird though. Does not believe there is grounds as a clear and indisputable error. There are grounds as a clear and indisputable error.
right.
Change that is to are.
Yeah.
And I would say instead
As
of
clear.
as, make it of a clear and indisputable
That's-
error in
yeah.
fact or law.
Yeah. Yeah,
Does that make sense?
it does now, yeah.
I'm just making sure you know where I was talking
I'm
about.
following you.
Okay.
Okay, so then we change cases finally.
Yay!
And then page 9,
Yep, yep.
and we're into familiar ground now.
Yeah, well, on 20, where it says case 2025, Chairman Gentile asked Young, Land Use Board's Administrator,
Comma.
comma.
To read.
Yeah,
Okay, good. Anything on page 10?
I have one in the paragraph that starts with Mark McConkey explained.
Yep.
The last line that says sunset period, it should be sunsetted period.
Okay. And on page 11, I don't have anything.
I got nothing.
Page 12, I don't have anything.
I got one minor thing at the bottom.
Me
Yeah.
too.
In the administration paragraph, right in the middle, sentence reads, she further explained that he board, it should be the
That
board.
one, Yep. Same one I had.
Okay. And page 13.
Yep, change that last line.
From elementary school, okay, to town hall lower level.
Well,
I'm like,
in the
wait,
morning.
was reading through this, I'm like, are we supposed to be in the
No, it's not
school?
posted that way at all, no.
but she sent us an email to tell us that.
Yeah.
Well, that's
Because I
because,
sent her one
that's
asking.
because Rich said, where are we meeting?
Oh,
One
okay,
thirty in the
yeah.
morning, just so I can make that for the record.
Alright,
Just for the record, the newest member caught that.
I make a motion that we accept the meetings from July 16th as amended for typographical errors.
Second?
Okay, go ahead.
Who seconded?
Doug.
Mark,
Oh,
We all did.
He's
I
an
second.
alternate,
We all did.
isn't he an
Put me
alternate?
down.
So who wants to do a toss-up? Who's doing it?
Pick it.
put Mark down.
His turn.
Okay, all in favor?
Aye.
Okay, approved. Okay, so the last thing is the ZBA minutes from the special meeting where, with a request for rehearing the zoning board of adjustments June 18th decision by Matt Johnson. So I didn't see anything
I only-
because I didn't read it.
I read it before it started, I only had two small little typographical things. The last paragraph on the first page, The sentence that starts with board took a different position, and it is a disagreement on it says pointed law, it should say point of law. And then on the second page, again, the paragraph that starts with Chairman Gentile asked the board, the line that starts with see any error in procedure, 3/4 of the way across, it says the same procedure, many, take out the word of, should just say many times. And the next line down, the only thing they would be able to stand on is new evidence, then it says comma, which that, comma, it should just say which, and take out the that comma, just which was not provided either.
Okay,
That's all I have.
unless somebody has any other typographical issues, then I move we accept the minutes of July 25th as amended.
I second, oh,
Okay.
Doug seconded.
All in favor?
Aye.
Okay, so, Kate, do we have anything else that you need to tell us?
Nope, I'm good.
Okay. Well, hopefully that's the last round of really intense minutes we're gonna have
You
in
could
a
even
while.
offer to do them if they really liked them. I
Uh-huh.
really could
Do we-
step out, trust me.
Do we need to discuss this at all, the changes to planning and zoning laws in 2025? Is there anything in here, has anyone read this, that
I haven't
No,
read it yet.
I've
that
read
has
it,
any
yeah.
implications for anything that we do?
I haven't read it
And
yet.
there's a whole piece about the accessory dwelling units.
I
Yeah,
started
because
to read it,
there's
fell
I think this
asleep.
has more to do for you guys than for us.
Yes,
And there's a.
and it really doesn't have that much to do, didn't make huge changes for us, it's pretty much stuff we do. So,
Where did you get that, Sharon?
It was in my
It's in the
packet.
packet.
It was
Yeah,
in my
I got
package,
Yeah.
I
It's on the
didn't have one.
back end, the last thing in the package.
yeah.
Well, here's my package, and I don't have one. So, no.
I didn't have that.
That's not, that was, I put that in
You
here,
put
so I
that in
got
to
it.
remember.
Here, Mark's giving me.
now you have one.
He's right.
All right.
Yeah, he didn't
Okay,
miss it, he
an
doesn't
oversight,
know.
okay,
I haven't
so,
read it.
yeah,
Yeah,
it would be,
okay.
it would be useful for us all to review it,
Yeah.
but I don't know that, critical for tonight.
So,
August, what's the date in August?
Today,
I'm sorry.
It's on there.
September.
September,
Yeah, September 17th.
1, 2, 3,
Yeah.
September 17th, yeah.
Okay, so we will consider, now, hopefully we won't have any more things, but as a minimum, we will have to consider whether to rehear the case, the Franklin case, which we heard last. We filed that, that was the one that came in on the Friday and was carried the
right.
Monday.
it's an
and-
STR, or,
It is an STR case, that's, remember, Mr. Franklin was requesting a grandfathered status based on being financially vested.
right,
Oh, I thought we heard that.
We
I thought
heard
we
that,
did
we
too.
heard the case, we heard the case,
uh-huh,
and we denied it because the house didn't go on the market until after the
Right.
ordinance change, and he didn't purchase it until,
After that.
well, he went under contract, and then, of course, yeah, so it's like, you know, but.
it all kind of mushed together, yeah.
It all kind of mushed together, but the bottom line is, at the end of the day, the real problem, the actual problem was this real estate agent didn't fulfill his duty as a fiduciary.
Right,
In one sense, that's not our problem, and it's very unfortunate for him.
Not our problem.
But the reality is that, it was filed for request for a rehearing, because he
Okay.
wants it bundled with the rest of them. The reality is, the only effect that the other cases will have on this one is if the judge throws out our ordinance on constitutional grounds. Not necessarily US constitutional grounds, but if he disallows the ordinance fundamentally because, you know, he considers we can't restrict an owner's right to rent a property, then, he'll be able to rent anyway.
but isn't that what the selectmen put in place, not ours?
Well, basically,
The town put it in
Town,
place.
yeah.
No, and we can test that the
We're
town.
doing the town's bidding, yeah.
Well.
Supporting the
We
town.
have the right, the legislative body of the town has the right to regulate usage.
Right,
Right.
right.
But it's been a long-standing contention in the courts as to whether you can, in any way, shape, or form, limit an owner's right to rent.
Yeah. Yeah.
So that's at stake, so.
Wow.
okay, so we'll have a motion to rehear that case.
Right, and that may be the only thing, unless Kate comes up with some other wild,
Has the deadline passed for submission for the next,
No.
for the September? No, it hasn't, so.
Anything could happen, yeah.
Okay, so September 17th is the next meeting, right?
Next week,
Sure.
deadline on Tuesday.
ZBA,
Oh,
thank you.
Sure,
Say September
thank you.
17th at 1800, 2 hours and a day before, and
That is my-
Gotta keep everybody sweet.
It's my big
Apparently they're small, so it
Uh,
can take two.
there being no further business before the board, I make a motion that we adjourn.
Second.
all in favor?
Aye.
Okay, thank you.
Thank you.
Thank you.
Thank you for the chocolate.
Thank you, Kate, for the chocolate.
Yes, it's Kate that brought the chocolate, so you.
Hey, Kate, some cake? Would you,
Absolutely.
You can have a bag, it's yours.
Yeah, more.
I know, I should bring some to the
God,
You don't have to limit yourself to one.
that is so good.
I bring stuff into the planning board every once in a while.
These are made in New Hampshire. The Lint Company is a New Hampshire company.